No, hold on. I opened up the file and it's got the wrong document on the front page. All right, this is People of the State of Michigan versus Jacob Bradley Johnson, file number 25-14177FH. Appearances, please.
Please know for the people.
And I'm Jeff Harrison. I'm here on behalf of Mr. Johnson. That is him on the video from the Wexford County Jail.
All right, thank you. We're here today for the entrance of a plea. Do I have advice of rights and a written pre-trial agreement?
I don't have an advice of rights, Your Honor.
All right, I keep telling you guys to get it. Go get it. We are a church. Recess. Have a policy to tell you to do it. Do it.
Proof that you'd applied for.
Hi, if I may interrupt, we just got a phone call from the Robertsons. They are en route. I guess Miss Robertson had to work nights, so she just returned home and they're en route on their way here. So if you want to give them a few minutes to come in, it's up to you.
All right. Sorry about this, guys. You would have thought they
We
would have
just got
said
the phone call. We literally just got it. Jennifer just got it.
Thought they'd have said something.
Yeah. All right.
When I
Thank
said
you,
it the
Judge.
other day. Thanks. I'm sorry, you guys. Have a seat a few minutes, okay? 2-6.
Everyone should be.
Michael Rose. I don't know where Jamie is. If she didn't show up, then I don't know.
Your Honor, we didn't have her check in.
Right. Okay. Who's from Mr. Cox's office here? I don't see anybody.
Hi, Your Honor.
Yes.
Good morning.
All right. Your appearance?
Attorney Hamza Sob on behalf of the plaintiff.
Mr. Rose, did you hear from the funding agency?
Not yet. I have not.
Did you provide us with proof that you'd applied for funding?
My wife should have brought it up there to you guys.
I don't know what that means. She wasn't even here on February 2nd, unless I wrote something that wasn't true on the register
No.
here.
No, she wasn't there.
Well, then why would she
February
have brought it up here?
Because my license is suspended and I couldn't take it up there.
We didn't get anything,
And-
did we, Linda or Jennifer?
I'm double checking now, Judge.
Mr. Sob, in the meantime, I'm going to ask that you give me a breakdown as to what is owed, please.
Your Honor, right to retain is $5,800. Court costs are $298.56. The total outstanding balance is $6,098.56.
How much, what kind of late fees are they charging?
The late fees are $75.
So how many months of late fees?
November, December, January, and now February.
So you've got $300 in late fees, and the rent to retain would only be $5,500 then, true?
True, Your Honor.
Okay. All right. Do you have anything there, Jennifer?
Judge, I do not see anything here.
Okay. So you had to bring that up. Where's Mr. Rose at? I'm losing him again here. Mr. Rose, you would have had to have somebody bring that here, so I can't give you any more adjournments. Any reason to dispute the figures that they just gave me?
No.
I'm going to give you a judgment after hearing versus Mr. Rose. And I'm going to give you a default judgment versus Jamie Rose. I want you to submit this to me today, if you will, please. The writ date in this case will be on the 5th, March the 5th. Okay, so again, it's after hearing versus Mr. Rose by default versus Jamie Rose. There was no prayer for relief for a money judgment, correct? You didn't seek money judgment?
We did, Your Honor. And
All right, well. I can give you a money judgment versus Mr. Rose. Was she, how was she served?
It was tacked, Your Honor.
So I can't give you a money judgment versus her. So the money judgment will be versus Mr. Rose only, okay?
understood, Your Honor.
All right. All right, good luck, sir. You have to be out or pay up 609,856 by March the 5th, okay?
Okay. Thank
Good
you.
luck. Thank you. Thanks, Mr. Sob. Do you have any others?
I do have one more
What
for 8:30 and then one at 9.
what
The-
apartment complex?
Epic Property Management.
Epic Property versus Ariana Shemilski, Dustin Lefevre, and James Van Horn, 2600221. Okay. Let's see here. Where is Ms. Shem? There you are. Ma'am, your name?
Ariana Shimilewski.
Did you, in counsel your appearance again?
Attorney Hamzi Sob on behalf of the plaintiff.
Did you apply for funding?
I did.
Did you hear anything?
And then I wasn't sure how to show you the proof. I have the paper right here. I didn't. I did get denied.
Okay.
Yeah.
All right. Why don't you give me a breakdown, Mr. Sob?
The rent to retain, Your Honor, is $1,043.85. Late fees are $150. Court costs are $262.95 for a total of $1,456.80.
All right. So, ma'am, I'm going to give him, you have any reason to dispute that amount?
I just wanted to let you know I've been laid off of work, so this is what I've been dealing with. I am working to get a new job now. I'm a single mom, so I just had to make sure I had a babysitter lined up. It was unfortunate. My papa just passed away, so I'm trying to get back on the roll of getting everything together.
Are you going to be able to pay this?
So right now I don't have the money. So I'm starting to get back into work again because I was laid off. So I'm not making as much as I usually would. So I have another job lined up because this one's
Okay,
not
so
working out.
You understand you're going to have to pay this or vacate by the 5th, right, of March?
By the 5th of March. Okay. Yeah.
Okay. So I'll give you a judgment, Mr. Sob. It'll be by default versus Lefevre. Was it Mr. Van Horn? I'm sorry, he was in hospice. He passed away?
Yes.
I'm sorry for your loss. I really am.
Thank you. Yeah, I just, Your Honor, I don't go to court much, and I was trying to make sure I figured out a way to tell you that, and I do it on my own, and I've done it so far it's just, the being laid off and then my papa passing away, and it kind of set me back a little bit. I'm just trying to get right back
Be
on
able to
track.
pay this by the 5th?
I do have a friend willing to try to help me out, so that's what I'm working towards right now. And then my taxes, that's what I was
Counsel, in
hoping.
your judgment, you put this, if defendant pays $850, if defendant pays $850 by March 5th, writ date extended until March 13th. So in other words, if you can pay $850 by March 5th, I'm going to give you until March 13th to pay the remainder. If you don't make the first payment, you're going to be evicted. If you do pay $850, you're going to have until the 13th to pay. I'll do that for you in light of the circumstances.
Okay, I appreciate that, Your Honor.
Okay. Anything else on this, Mr. Sobey? You'll make sure you get me these judgments today.
Will do, Your Honor.
Thank you very much. Have a good day. Good luck to you, man.
Thank you.
Harlock Holdings LP versus Brian Epps and all occupants, 2600433.
Your Honor,
Brian Epps,
he just requested to go in a breakout room with his client.
with the other side, you mean? Okay, no
Yes,
problem.
yes.
I'll pass that. Deerfield versus John DeJesus and Destiny DeJesus, 2600438.
Good morning, Your Honor. Daniel Landman, P35797, appearing on behalf of the plaintiff.
Good morning, Mr. Landman. Do I have either one of these individuals, John or Destiny DeJesus here?
I see Jonathan.
Where is he at? Oh, your name, sir? You have to unmute. Tell me your name. Should be on the bottom left-hand corner of your screen.
I'm sorry, I've never used Zoom and I didn't.
You're fine. Your name?
Jonathan DeJesus?
Is Destiny your wife or what?
Yeah, she's my wife. She's at work. I had to drop her off and.
All right. Did you listen to and understand the rights?
Yes. Yes, sir.
Do you wish to apply for funding or speak to a lawyer?
I like to apply for funding. I should get my taxes soon, and I was hoping to get them before all this. I got a message from the IRS on Saturday saying they would be in my bank account within the next few business days. But it hasn't come yet. I'm waiting.
Are you going to apply for funding?
Yes, sir.
All right. That entitles you to a 2-week adjournment. We're going to adjourn this 2 weeks. You have to bring proof up here.
Okay.
You have to bring proof up here this week that you've applied for funding, okay?
Okay.
Bring it to the court. Adjourn 2 weeks until what? We doing on this?
March 9th at 9:00.
Okay, adjourn 2 weeks to March the 9th. You said at 9, Linda?
Yes, Your Honor.
At 9:00 in the morning, we'll adjourn this too, but you have to bring proof up here that you've made application for funding, okay?
Okay. Thank you, sir.
All right, bring it up this week. Thank you. Deerfield versus Brittany Montroy and Aaron Montroy, 2600441.
Daniel Landman, appearing for the plaintiff.
Your Honor, we did not have anybody check in on either defendant.
Okay, you can go ahead and take a default. You paid for a separate mailing, second mailing.
Thank you, Your Honor. We'll submit the judgment.
Can you give me the breakdown?
Absolutely. This one's a little complex, Your Honor. There's a lot rent owed of $1,680, home rent of $1,353.72, home payment of $1,616.28, one $45 late fee.
Wait a minute. Slow down.
Sorry.
That's okay. You're right. It is strange. You got lot rent of $1,680.
Yes.
Then you said you've got home rent of
Home
13.
rent of
What's that?
16,1628.
And you gave me some other figure of
Yes, a loan,
1353.
1353.72 repayment of a home loan.
Geez. Okay. Well, and the $45 late fee, and then what's your cost?
$45 late fee and 122.17 of water and sewer.
Jeez.
Less payments of 1610.47. And that all works out to $3,206.70.
Sorry, repeat that again, this final sum.
3206.70. And there's costs of 225.43 for a total of 3432.13.
Okay. Writ date will be on the 5th. You can present your judgment, and that will be by default,
Thank
okay?
you, Your Honor.
All right, and I got one more with you. I've got Deerfield versus Patrick Phipps and Jessica Martin.
Daniel Landman for the
260443.
I'm sorry, Daniel Landman for the plaintiff, and Mr. Phipps is present.
Yes,
Mr.
I am.
Phipps,
I'm Patrick Phipps.
your name? Okay.
Patrick Phipps.
Is Jessica Martin here?
No, she doesn't live with me anymore. That's my mother. She's been off the lease for a while, so I don't understand why she's even on here.
Did you listen to and understand the rights on the video?
Yes, Your Honor.
You wish to speak to an attorney.
What was that?
You wish to speak to an attorney.
No, sir.
Do you intend to apply for funding?
Well, I do because I'm kind of in the same boat as the last person. I was expecting to have my taxes back by now, but they haven't been. So I would like to apply for some funding.
All right, we're going to adjourn this 2 weeks. You have to bring proof that you've made an application for funding up here this week, okay?
All
and
right.
I'll adjourn this to March the 9th. Is that at 9 again?
Yes, Your Honor, that's fine.
Adjourn 2 weeks. And you bring your application for funding up here, okay?
All right. Thank you.
You proof that you filed for one.
Yes, Your Honor.
Okay. I wish you well. Good luck.
I appreciate it.
Thank
You guys have a great day.
You too. Thanks. Thanks, Mr. Landman. Do you have any others?
Your Honor, I do not have any others at 8:30. I do have 9 o'clocks and 9:30s.
Okay. Have a good one. Thank you.
Thank you.
I'll get you. Harlock Holdings versus Brianna Epps, 2600433. Are they ready?
Good morning, Your Honor. Kevin
Yes, Your
Callahan,
Honor.
plaintiff.
Okay. Good morning, Mr. Epps. Start your, or ma'am, start your video. I can't
Yes,
see.
yeah.
Okay. Good morning. Your name?
Good morning. My name is Brianna Epps.
Did you listen to and understand the rights, ma'am?
Yes, Your Honor.
Do you wish to speak to a lawyer or apply for funding?
I have spoke with a lawyer and I have not applied for funding, Your Honor.
Well, I don't mean the plaintiff's lawyer. Do you wish to speak to a lawyer?
No, Your Honor.
Okay. Did you resolve anything, Mr. Callahan?
We have a conditional dismissal I'd like to enter into with the defendant.
Go ahead. Give me the terms, please.
The terms are the rent to retain through the month of February is $2,668.92. There is $224.43 in court costs and statutory attorney fee. That's broken down as $82.43 in filing, $67 in service, and $75.
I don't need that. I don't need that.
Okay.
Do you have late fees encapsulated in this $2668.92?
There are. Yeah, it's about $150 in late fees, Judge, at $50 per late fee.
So it's $150 in late fees, and therefore you've got $25,1892 in past due rent. True?
Correct.
And your total amounts to?
With the court costs is $2,893.35.
Good enough. Submit a judgment to, I'm sorry, what are the terms now?
So we're doing a conditional dismissal. I'm going to email that conditional dismissal with Miss Epps to Miss Epps today for signature and entry. Miss Epps is going to pay her monthly rent, which is $762 plus 1/2 of the past due balance, totaling $2,208.68 by the 5th of March. Ms. Epps is going to pay her April rent timely by April 1st, and then the balance of this judgment will be paid by April 30th to give her time to catch up.
You agree to all those terms, Ms. Epps?
Yes, I did, Your Honor.
Since you're unrepresented by a lawyer, you have 3 business days to come in here. If you don't understand something, fill out a motion to set aside that conditional dismissal, and you have 10 days to appeal. Do you understand that?
Yes, sir, I do, Your Honor.
Do you want to see the judgment, or do you want to give him permission to sign your name to that proposed consent judgment? It's up to you.
I'm not worried about it because I agree. So however it's convenient, it's fine.
What do you want to do, Mr. Callahan? She's giving you permission.
I'll sign with her permission, and I'll also send a courtesy copy to Ms. Epps so she has
Thank
it in her email and she can object if she needs to.
I'll hope that you'll get me that today, okay?
I will, definitely. Thank you.
Thank you both. Good luck to you both. Thank you.
Thank you so much, Your Honor.
You're welcome.
Thank you.
All right, LVNV versus Christopher Zakaria, 2504529.
Good morning, Your Honor. I'm here for the defendant, Christopher Zakaria at Sunny Miller, P88410.
Who's here for LVNV?
Your Honor, I don't think I have anybody for them.
If I had a nickel for every time we had to call a lawyer.
Oh, I'm sorry. I do, Your Honor. I take that back.
Okay.
I'm just figuring out some of these names.
That's all right. Take your time. Bring them in whenever they're ready. Frank Price is the lawyer. I don't see his name out there.
And which case is that for, Your Honor?
Oh, this is LVNV.
Yeah, I'll probably take that one. Frank's the same firm as I am, so I'm sure that's the one I'm here for.
LVNV Funding versus Christopher Zakaria, 2504529. Okay. Ms. Miller, your name again, and then Mr. Nate.
I apologize, Your Honor. I'm here on behalf of the defendant.
Okay. Mr. Nate, your appearance.
Preston Nate, P77884 on behalf of LVNV.
All right.
Sunny Miller, P88410 on behalf of defendant Zakaria.
Is she here or Christopher Zakaria here? I'm sorry. Or not?
I do not see them today.
No, Your Honor. That person did not check in.
Did you guys, is there some kind of a defense or what is this? This is, oh, I'm sorry. This is not a landlord tenant case. My apologies. Okay. So we're just doing, what is this, a pretrial? Yes. Okay, sorry. You guys want to talk and try to resolve it, or you want me to just give you dates?
I think just dates today is fine, and we work together quite a bit. We'll continue to work on this one.
Yes, I'd agree, Your Honor.
So let me just put in the all right. L223. All right, let me just get everything here. Okay. So I'm going to give you discovery until, let's see. April 24th. No motions heard on the date of trial. All motions for summary have to be filed and heard not later than 20 days before the trial date. Nobody demanded a jury. We're going to give you a trial date. I'm going to put down 1/2 hour on this. You have to file your witness list by March the 24th. So witness lists are due March the 24th. And you don't have to file a trial brief. If you choose to file it, you have to file and exchange it not later than 7 days before the trial date. And I think that's pretty much it. I'll give you guys your trial date and get you out of here. Give me a date, May.
How about May 18th?
That's good.
At 10 o'clock?
May 18th at 10 o'clock will be the trial date, okay?
That'll work. Thank you.
All
That'll
right,
work.
I think that's it. Anything else I need to bring up, either one of you? No?
No, Your Honor, thanks.
No, Your
Have a
Honor, thank
good-
you.
Have a good day. Thank you very much.
Thank you.
So this one, I'm gonna give, I don't know what part it is. Granite Televalley versus, I'm getting rather agitated that these people aren't here on this other case. They were supposed to be here at 8:30. I'm waiting 10 more minutes. They're not here. I'm giving you a judgment. I don't understand this. Granite Televalley versus Delicula, Monet, Sanchez, and Brandy M. Kilgore, 260045. All right.
Danny Landman, Your Honor, appearing on behalf of the plaintiff.
Do I have either one of these individuals here, Sanchez or Kilgore?
Your Honor, Miss Sanchez did call me this morning and she said that she has the flu and did have doctor's notes. She did send those in. I do have those in front of me. I can run them down if you want, but I did tell her to zoom in and it does not look like she has
Give him a
checked
default.
in. I will give
Yeah.
her a call.
Okay. Go ahead, Mr. Landman.
Your Honor, this is actually a second hearing. At the prior hearing, the tenant indicated that they were applying for assistance, and I believe they may have submitted the rental assistance form. I'm not certain of that, and I would request confirmation of that from the court.
Did we get the application?
I'm checking right now, Your Honor.
Okay. She still hasn't zoomed in. I don't go for this. I'm sorry. I'm gonna give you a default unless you don't want me to.
No, I'm very happy to.
Your Honor, there is proof.
Well,
Frontal.
that was on February the 2nd. This is the 23rd. I wrote down, what did I write down? Ms. Sanchez to appear in person on February 2nd. The original hearing was for January 27th. They can't just not show up. I'll give you a default.
Thank you, Your Honor.
Go ahead and give me your breakdown.
I'm working on that right now because this is another case where there were payments.
Okay, take your time.
Okay, thank you, Your Honor. I am showing rent to retain of $2,855.38. I am showing utilities of and I apologize, Your Honor, but these go back to December. Total utilities, Your Honor, are $634.72, and that's sewer, water, and trash.
Fine. What else?
We have late charges of we have one late charge of $35.
Okay.
We have NSF charges of $225. So that adds up to a grand total, Your Honor, of $3,750.01. And then we have payments of $1,128. resulting in a balance of $2,622.10. Court costs are $231.82, so the total judgment that we are requesting is $2,853.92 with a writ date of March 5th.
Go ahead, I'll give you that. Default judgment's entered in favor of the plaintiff and against defendants. The writ date will be March 5th, 285392, you said, right?
That is the total, yes, Your Honor.
All right, so you can submit your judgment on that. Do you have any more here?
Only at 9:30, Your Honor.
Okay, all right, thanks. I want to know what Mr. and Mrs. Robertson said, Jennifer or Linda, whoever talked to them. They don't get to just show up an hour and 10 minutes late.
Your Honor, Jen Wiseman spoke to them and they said they would be here in a few minutes.
Well, they should have told me this when I scheduled the court date. They don't get to do this. I hope it was conveyed. They better hightail it here. I'm giving.
Do you want Jen to give them a call? She does have a phone number.
If they're not here by 22, I'm entering into judgment for the plaintiff. That's what I'm doing. They don't get the, what is this? They act like they're showing up for lunch or something. Hidden Gardens versus Clarence Smith, 2600446.
Yes, sir.
Your name, sir?
Clarence Smith.
Who's from Pallets' office on this?
Your Honor, Attorney Ian Morton of Pallets Law, P67892.
How you doing, Mr. Morton? I haven't seen you in a while. I thought you left or something. Where's
Your Honor,
Ms.
I think just
Kingsley?
like my wife, I think everybody gets sick of me after a while.
Where's Ms. Kingsley at? She hasn't been in front of me either.
She's enjoying the beautiful, luxurious city of Flint.
What do you mean?
She's in the city of Flint right now in court.
Oh, I see. She's still with your firm, though.
Absolutely. Yes, she is.
Okay. Mr. Smith, did you listen to and understand the rights?
Yes, sir.
Do you intend to apply for funding?
I have. I'm waiting for,
When did you apply for funding? And with who?
Last week with the Department of Health and Human Services, and I used some resources from my employment.
I'm going to adjourn this 2 weeks. I'm going to set this for March the 9th at 9 o'clock. You have to bring up proof to the court this week that you made application for funding, okay? So you have to bring proof that you applied for funding. You understand that, sir?
Yes, sir.
All right. Do you have any questions?
No, but may I explain my situation, sir?
We don't need to have a discussion here yet. You're entitled to a 2-week adjournment.
Very well.
I mean, if you want to say something, I can listen, but.
No, thank you, sir.
Okay. I mean, you want to say something? I'll be glad to listen. I didn't mean to cut you off like that, but you're entitled to a 2-week adjournment as long as but you need to bring proof up that you made an application for funding sometime this week. Okay.
Absolutely.
You guys are late.
So last night I was on a surgery, so I got picked up as soon as I could. I worked 45 minutes with it.
All right. Are you guys going to talk and see if you can resolve this? You want to talk? You guys?
Yeah.
John, take them to a separate room, jury assembly or what have you. All right. So that's what I'll do, sir. I'll adjourn this to March 9th at 9 o'clock. You bring proof up here that you made an application for funding. Okay?
Sure.
All right. Any questions?
No.
All right. Good luck to you, sir. We'll see you here in a couple of weeks. That's the only one you guys have, right, Mr.
No, Your Honor, we had a few. I had 9 o'clock listed for Meadowlands as well, unless the court shifted it to 9:30.
Okay, yeah, I got it. All right. You're all set, Mr. Smith. Catherine Wilson versus Michael Harajli. Harajli, 2600525.
Morning, Your Honor. Attorney Hamza Silva on behalf of the plaintiffs.
Good morning, Your Honor. Attorney Albert Sala, PA 3929 on behalf of the defendant, Michael Harajli. Both parties are present in the Zoom as well.
Did you, is Mr. Harajli here or not?
Yeah, he's on the Zoom. I
don't see him. Oh, there you are. You have to start your video, Mr. Harajli.
Yes.
Start your video, please.
There we go.
Your name?
Michael Harajli.
Okay, so this is just a termination, right?
That's
Correct, Your Honor. I did request a breakout room with Mr. Salah if that's possible.
Yeah, we'll be glad to do that. Put you in a breakout room. Is there a defense, Mr. Salah?
It's my understanding that he's actually vacated the premises, but there's some property that's left over behind. Attorney.
Well, why don't you
Silver-
guys go into a breakout room? I'm sure you can figure it out.
Thank you.
Okay.
We're very close to it. Thank you.
Okay, good. Put Mr. Salah and Mr. Sobe in a breakout room if you would.
Yes, Your
Meadowlands
Honor.
Versus Nathina Leslie, 2600611. Good morning, ma'am. You have to unmute and state your name.
Nathina Leslie.
And
Your Honor, for the record, Attorney Ian Morton, Appellate's Law on behalf of Meadowlands.
did you listen to and understand the rights, Ms. Leslie, on the video?
Yes, I did.
Do you intend to apply for funding or do you wish to speak to a lawyer?
Hopefully the taxes should be here in the next week or two, so I don't think I should need funding, but I can go ahead and just start the process just in case.
You want us, you're going to apply for funding? Is that what you're telling me?
If I should, if the taxes aren't here in time, do you know what I mean? I'd rather
No.
apply for it and not need it than not have it, and I can't apply. Does that make sense?
No. Okay.
Like I'm saying, like, I'd rather
You're
apply.
entitled to a 2-week adjournment if you're applying for funding. If you're not, you can go into a breakout room with Mr. Morton maybe and work something out.
I'll just apply for funding. That way it's, you know what I mean, the time doesn't pass and it's too late for me to apply. And then if I do end up having the lot rent beforehand, I won't need it.
March the 9th at 9:00, okay?
Okay.
And you have to bring proof up here that you've made your application for funding sometime this week, all right?
Okay.
I do wish you well. Good luck.
Thank you so much.
Thanks, Mr. Morton. Wait a minute, that one's Woodhaven Place. Woodhaven Place versus James Cole, 2600614.
I see Mr. Cole present, Your Honor. For the record, Attorney Ian Morton, Appellate's Law on behalf of Woodhaven Place.
Okay, so I don't see him. Where are you at, Mr. Cole? Oh, there you are. Start your video, sir. And tell me your name, please. I can't hear you.
Go ahead, Honor.
You got to start your video, sir.
Hang on.
You do have.
Oh my goodness.
Okay.
All right, there you are. Now listen, perfect. Can you look at me so I'm not looking at your head? Thank you.
All right. I have a hard time hearing, you know that.
You have what?
I have a hard time hearing. That's why I got my ear towards it.
Okay. Did you listen to and understand the rights on the video, Mr. Cole?
Yes, Your Honor.
Do you wish to speak to an attorney or apply for funding?
I'm going to try for funding.
All right. You have to provide us with proof that you've done that by bringing it up here this week to the courthouse. That buys you a 2-week adjournment. I'm going to adjourn this to March the 9th at 9:00 in the morning.
Thank you,
Okay.
Your Honor. Thank you,
All
Your
right,
Honor.
so,
Have a
so
nice
make sure
day.
you bring proof up here within by Friday, okay?
Yes, Your Honor.
Thank you. Have a great day.
You too, Your Honor.
Woodhaven Place versus Tony Douglas, 2600615. Ms. Douglas, good morning. Your name, ma'am?
Tony Douglas.
Mr. Morton?
Your Honor, again, Attorney Ian Morton on behalf of Woodhaven Place.
Ma'am, did you listen to and understand the rights?
Yes, Your Honor.
Do you wish to apply for funding or speak to a lawyer?
I'd wish to apply for funding.
Okay. All right, so you're applying for funding and we're gonna adjourn this to March the 9th and at 9 o'clock, and you have to bring this up here, okay? You have to bring up proof that you made application for funding this week sometime to the courthouse, okay?
Yes, sir.
And I'm adjourning it to March 9th at 9 o'clock. Any questions?
No questions.
All right, good luck to you, man.
Thank you, Your Honor. Have a great day.
You too, thanks.
Thank you.
Woodhaven Place versus Roland, 2600616.
Morning, Your Honor. Mark Rowan here.
For the record, Your Honor, Attorney Ian Morton on behalf of Woodhaven Place.
Okay, good morning, Mr. Roland. Did you listen to and understand the rights?
Not yet.
Pardon?
Yes, I did.
You wish to speak to a lawyer?
No.
You intend to apply for funding?
No.
The total amount that's owed right now, Mr. Morton, no need for a breakdown.
Okay, the total, Your Honor, is $1,985.82. And just for Mr. Rowland's information, that might be slightly different than what's listed on his ledger because we do make adjustments for the late fees.
What was that total again, sir?
$1,985.82. So 1985.82.
Do you agree that you owe that amount?
Yes.
All right. What do you guys want to do?
Can we enter in a breakout room and discuss it?
Yeah, I'll put you in a breakout room. I'll put you in a breakout room.
I'll do it right now, Your Honor.
Yeah, I don't know why I'm saying I will. All right, you guys, what case did you have again, Mr. Oh, I'm sorry. I got files all over the place here.
It's all good. Wilson versus Harajli, Judge.
Okay, cool.
Okay, Catherine Wilson versus Michael Harajli, 2600525. Okay, everybody's name again, please.
Attorney Handisov on behalf of the plaintiff.
Albert Sala on behalf of Michael Harajli.
All right, Mr. Harajli, your name again?
Michael Harajli.
You guys have a resolution, and if so, what is it?
The plaintiff is present too, if you want to get her appearance in.
Oh, Ms. Wilson, I'm sorry.
Hello.
It's like Hollywood Squares over here, you know? Your name?
Catherine Wilson.
All right. What do you guys, is there a resolution?
Judge, there's not a formal resolution right now. We've had great conversation even before this hearing, Attorney Soba and I. We just need additional more time because it's an exchange of property. We're trying to figure out what property and how to get it out of the property so that we can effectively vacate the home and dismiss this case hopefully in the future. And if we're able to do that, then great. There won't be any reason for an additional hearing in the future. So we're just asking for a brief adjournment, 30 days if you can.
Can you work on it a little quicker than that?
I'm sure we can.
All right. Let's go 3 weeks, Jennifer. Or Linda, whoever's. So is that going to be the 16th?
Like it.
Linda, are you out there?
Yes, I'm sorry, Your Honor. I wasn't muted.
No
Or
worries.
unmuted. March 16th at 9 o'clock.
March 16th at 9 o'clock. Hopefully, we'll have it resolved then, okay?
Your Honor, will that be another pretrial that day?
Well, this is summary proceedings, so if you guys haven't resolved it, I'm probably going to have a hearing and I'm going to determine whether or not, I mean, look, it's for termination of tenancy, right?
Correct.
they're entitled to the property within 10 days actually of today's date. If Mr. Sob, I presume you have no objection to this request for an adjournment, right?
That's correct, Your Honor. We're going to transfer over some property and then this gets dismissed.
So that's fine. So I'll adjourn it 3 weeks. If you guys haven't resolved it, I'll just, unless there's some kind of defense underlying, I'm going to give them possession of the property. Okay?
Yep, sounds good, Judge. 9 a.m.
Thank you very much. Have a good day.
You as well, Your Honor. Thank you.
Thank you. Golden Management versus Cynthia Davy.
Yes, sir. I'm here.
2600194. Ma'am, can you just sit right there? There you go. Tell me your name, please.
Cynthia Davy.
All right, I need a better connection. State your name again. You're frozen, if you can.
Cynthia Davy.
Are you in Flat Rock right now?
Yes, sir.
All right. Ms. Lowney, your name?
Good morning, Your Honor. Sarah Lowney on behalf of the plaintiffs.
Ms. Davy, did you, we've already gone through all this. We adjourned it. Did you guys figure this out?
Yes, we did. We just submitted a conditional dismissal, Your Honor. So the court should have that.
You want to tell me the terms?
Yes, of course, Your Honor. Sorry, I'm in Warren District Court right now.
No problem. Okay. You ready?
Ready, Your Honor. In terms of today, we're agreeing to a conditional dismissal. Ms. Davy is going to pay $793.68 on or before March 5th, 2026. 4B has been checked, 7 has been checked, and MCR 4.201J is explained as well.
Ma'am, since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside this dismissal. You also have 10 days to appeal. Do you understand that?
Me?
Yeah, you.
Okay.
You understand that? Do you understand that, ma'am?
You're breaking up.
All right. Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the dismissal, and you have 10 days to appeal. Do you understand that?
Yes, sir.
You have to pay $793.68 by March the 5th or else vacate. If you don't do either one of those things, this will convert to a judgment and you'll be evicted. Do you understand that?
Yes.
I can't hear you, ma'am. Where are you? Where? Okay. All right. Good enough. You submit your paperwork and I'll go ahead and sign the order. Okay.
Perfect. Thank you, Your Honor. Thank you, Ms. Davy.
Thank you. Thank you both. Have a good day.
You too. Get out of this. Yeah. Okay.
All right. I think I've got. Yeah.
Here you go.
Tanglewood.
Oh, come on. Why are you wearing this?
Tanglewood versus Alicia Shabazz. 252600228. Shabazz, your name? Start your video, unmute, state your name, please.
My name is Jamie Rogers.
Where's Alicia Shabazz?
Alicia Shabazz is not here.
Oh, God. Hear me out. You're pay out. Okay.
I'm the tenant. I'm the
Lawyer
one
on
who
this
pays
case. Mr. Morton, your name?
Your Honor, for the record, Attorney Ian Morton, Appellate's Law, and this, are we back in front for Roland?
No, I called another case here. We'll do Roland next.
Okay.
This is Tanglewood versus Shabazz.
Yes, Your Honor. For Ian Morton on behalf of Tanglewood. Thank you.
I don't remember what happened here. Jamie Rogers, I believe. indicated she was an occupant. Shabazz failed to.
So acknowledged she is, Your Honor, and we are ready to proceed as well. Thank you.
All right, very good. Opening statements, or are you waiting?
I'll do it short, Your Honor.
Pardon?
I'll keep it short, Your
All right, very good.
Honor. Your Honor, today we're here, it's been trial. Today, the court will hear testimony from D'Angelina Terrell, who the court will hear was in a relationship with Mr. Savvy. They have 2 children in common. The court's going to hear from Mr. The events that occurred on September 24, to include an incident with Mr. Royce Savvy where she was pushed after trying to put their children to bed. And I believe at the end of this testimony, the court will see her testimony, see her demeanor, and find the defendant guilty beyond a reasonable doubt.
All right, very good. Skinner, would you like to give an opening statement, reserve, or waive?
I'd like to give one, Your Honor, very quickly. Your Honor, this case, as you heard counsel say, goes all the way back to September of 2024. At that time, my client, Mr. Rezavi, was and is a veterinarian, a National Guard veteran. He was living in Pittsfield Township, sharing custody with the complainant, Ms. Terrell, of 2 children that he thought he was the father of, and later learned that she had lied to him, was not the father at all, which I think will reflect on her credibility, which is clearly going to be an issue in this case. But nonetheless, they shared custody at that time, 50-50. He had the kids, and he invited Ms. Terrell over. You're going to find that their relationship was toxic, probably at best, but they still did sometimes hang out. And that night they were planning on hanging out a little bit, so we invited them over. The kids would not go to bed, being rambunctious because mom and dad were together. It was getting late, so John told her, "You got to go." Over the course of about 45 minutes, he kept saying, "It's time for you to go," for lack of a better legal word, revoking her ability to be in his apartment. She told the police she protested. She didn't want to leave. She wanted to hang out with the kids, and that caused some friction. As for what allegedly happened, Your Honor, my client will tell you that as he's standing in the doorway saying, "I'm going to get your purse, it's time to go," she loses her cool, smashes by him, pushes him up against the wall where he smashes his head and shoulder against the wall, leaving a divot in the wall and redness on his head. She runs, grabs the phone, and calls police. Now, what she tells police, Your Honor, is that he pushes her and that he smashes his own head against the wall, which I think the physical evidence, my client's testimony, and he will testify in this case, will definitely belie that. Hopefully at the end of this case, you'll find that this was toxic and this was immature, but this was not criminal, especially at Mr. Rezavi's hands.
Okay. May I call your first witness?
Thank you. People call D'Angelina Terrell.
And please come forward to be sworn.
Take a seat, raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yeah, see, state spell your first and last name correct, please.
D'Angelina Brennan, Beangelena Brennan, but my former last name is Teper.
Go ahead, you may inquire.
Thank you, Your Honor. And you go by Lena?
Yes.
Oh. Lena, do you know a John Rezavi?
I do.
How do you know him?
Bartender when we were both living in Manhattan, Kansas.
Did you have a relationship?
Yes, it was one of the friends with benefits. And to like a romantic relationship.
So you had a kid together? Okay. If you saw John today, would you recognize him? Is he in the courtroom right now? Can you identify something he's wearing and where he's sitting? And where's he sitting?
On the left side, the courtroom to the farthest left.
Okay. Your Honor, please let the record reflect that this witness has made an in-court identification of the defendant.
Record shall so reflect.
So I'm going to direct your attention now to September 24th of 2024. On that date, were you at 3341 Primrose Lane? And is that in Pittsfield Township?
Yes.
County of Washtenaw?
Yes.
State of Michigan? And on that date at that location, did Mr. Rysavvy do anything to you that made you call the police?
Yes, so, he had asked me to leave after, putting me against the bed, and I was trying to do so, but I didn't grab my purse. As I was walking to grab my purse, he had cut me off and started pushing me more towards the stairs. And, it was like, I don't know how long it happened. I just knew that I started hearing the kids cry. And I told John, I was like, hey, the kids are watching their phone. We kind of sound all of it. And then the walls were up.
Okay, so let's kind of start back in the beginning. Whose residence is that?
It's John's residence.
Okay, and how did you end up being at that residence on that day?
On that day, I went to class and we were in the middle of the place, so they said, you had worked on that. And he had asked me to pick up a target order that he had placed that was ready. And I told him I would do that. And he took on the phone and asked him if the kids would like to know, because I didn't want to go inside. Because I knew that my presence would like rile them up. And I didn't want to stir them up right before bed. He told me they were sleeping. I had a clicker to his garage because it was kind of like a townhouse condo situation. So I opened the clicker, and before I can even open the door, our eldest son, Alexander, opened the door. And I told John, because he was getting there, I was like, don't worry about it, I'll just put him to bed for you. And then we could like kind of talk later, because the whole point of me being there was to talk. I forgot that part, but we were just gonna hang out and talk.
So then, sorry to cut you off. So you got it there. Kids are awake. You go in the house and you're going to put them to sleep.
Yes, I told him well, at the time I thought it was just one son, but then I saw the other son was awake too. So I said, I'll put on two sleep. And we could talk right there. In the middle of putting Arthur to sleep, Alex had fell asleep. And John had came in, and he was just saying, like, they don't do this while you're here. It doesn't go like this. They're only doing this because you're here. And I told him it was fine because Alex had just fell asleep and Arthur was on his way to sleep, like, just give me like 30 minutes. And Arthur should be asleep. And the second time he came into the kid's room, that's when he asked me to leave. But at that time, Arthur was like 2 seconds away from actually like being into deep sleep, and I asked him if I could stay just a little bit, just so he could fall asleep, and then I'll leave. And he was like, no, you need to leave now. And I was like, okay, fine. And the way he was standing from the room entrance. And so I was going that way, and he was like, no, you need to leave to the bathroom. But the way that their door is set up is like, when the room entrance door is open, it blocks the bathroom doors entrance. So I moved the door.
The hallway door?
The entrance to the room door.
Okay.
To get into the bathroom, because the bathroom cuts out into like the little hallway that his house has. And so when I did that, he was like, bitch, did you just try to close the door on me? And I was like, no, I'm just trying to leave. And then he cut me off as I was trying to get to the kitchen to grab my purse and stuff. And that's when he started pushing me. And I kind of started pushing him off of me and asking him to let go of me. And he wasn't trying to let go. He was like, no, you need to leave, you need to leave, you need to leave. I was like, I'm just trying to leave. I was like, I'm just trying to grab my purse. And that, I don't know how long that went on. I would maybe say like 2 to 3 minutes of him trying to push me and me trying to like get him off me, because the way that his house is laid out, there's like a small, short set of stairs and then a very long set of stairs, and tile at the bottom of those long set of stairs. And in that moment, I was scared that he was trying to push me down the stairs. Because that's how badly he wanted me to leave. And like I said earlier, the only reason why he like kind of let go of me is because I said, hey, John, the kids are watching, they're crying. And they were, and they were really scared, and I called the police. And as I told John I was calling the police, that's when he decided to hit his head against the wall and said that I hit him. I was nowhere near him at that time. I was like as far away as I could be trying to call the cops.
So how did this whole incident make you feel?
It made me feel scared because like John and I have gotten into fights before. But like I never felt like my life was in danger. I think I was the only time I was like, wow, this man's really trying to hurt me. And I couldn't even tell you like what I did wrong to even make him want to like try to like that.
Your Honor, may I have one moment? And I know you mentioned your 2 sons. Are those 2 sons you share with Mr. Rysavvy?
Yes.
So he is their parent?
Yes.
Okay.
Bowder isn't his biological son. That's something we found out later down the road. But not at the time. We found out, well, John did a DNA test on Alexander, like a month or 2 after the incident happened, and found out that he wasn't his biological son.
Okay. And that's the older one?
Yeah, that's Alexander.
And the younger one?
Is Arthur.
And was the same testing done?
I just only know the one for Alex and not Arthur.
Okay. All right.
I have one more moment, Your Honor.
Nothing further to this witness, Your Honor.
All right, cross-examination.
Thank you, Your Honor. Mr. Brennan, good morning. Let's start with the location at Primrose Lane. That was Mr. Rysavvy's house, yes?
Yes.
You were not on the deed, you were not on the lease, you were not on any sort of documentation, correct? You had your own house or location elsewhere, yes?
Yes.
So I think you told the judge and the prosecutor, he told you to leave several times, yes?
He only asked me to leave once. And then when I was trying to grab my purse, because it was in the kitchen area, that's when he was like, no, you need to leave, but I can't leave without my keys or my wallet.
If I heard you correctly earlier, I think when the prosecutor was asking questions, you said, and I quote, give me 30 minutes. Is that correct?
Yes, for the kids, because he didn't ask me to leave at that time when he came in the first time. He was just getting agitated, saying that they don't do this while I was here.
So if you're asking to give me 30 minutes, what are you asking him to do? What?
I said, give me 30 minutes so I could finish putting our youngest son, Arthur, to bed. because the whole point of me being there was to talk and hang out.
Okay, so give me 30 minutes is in response to him telling you it's time to go.
Didn't ask me to.
You use the word with the police, who I think Officer Branch is here over my shoulders, that you protested. I think that was your word on the video, correct?
I didn't protest. I just said that I wanted to finish putting them to bed because I was there and I knew the moment I left, it would rile them back up.
Do you recall using the word protest to the officers? I protested for 30 minutes.
Say,
Ma'am, with respect to a 911 call, what was your intention in calling 911?
well, one, I still haven't had my purse at the time to leave. So that was the other intention was so that I could be able to leave safely, because at that point, he just put his hands on me, he just tried to push me. I just wanted to leave.
So I'm curious, and why is the call and the about him smashing his head in the wall repeatedly? Why are you telling the dispatchers that?
Because he just did that as I was calling them. Like the moment I said I'm calling 911, he started hitting his head against the wall. And that was very confusing to me. And so I let them know because I wasn't near them. In fact, the kids were the closest to me. And I informed them that that there were kids present and that what had happened was that he was trying to push me.
I mean, you guys had a custody arrangement at that time, correct?
Yes.
It was 50-50, correct?
Yes.
In response to the question I think the judge asked you, you had told Mr. Rasevi that Alex was his child, yes?
Yes.
And he was paying support for him, yes? Continues to, yes? You had the children 50-50. This was his night on September 24th, 24, correct?
Well, so that's a little tricky because the custody agreement actually states that on Tuesday, I pick up the kids from school. But because I was going to school at that time, I had asked him if he could additional.
So whose night was it on this night?
It's technically mine.
Okay. And this particular night, you guys had 50-50 custody, correct? Did you seek to try to change full custody after this?
Not full custody, but I definitely felt like after this incident, John's behavior has grown increasingly concerning, to the point that the kids were coming and telling me very concerning things.
Now, Ms. Brennan, when you first gave the story to the judge, you said that my client had sort of his hands up and was stopping you from coming back into the apartment. Is that accurate?
I would say accurate. He actually like was pulling me by my shirt and then pushing me by my shirt, if that makes sense.
Did you have any sort of stretched out shirt, any marks, any injuries, anything that you could show the police to what we call corroborate that?
I don't think so.
Did you have any injury whatsoever?
No.
To your knowledge, did you see injury to Mr. Rasevi's head?
No.
But of course, your testimony is that he put his own head into the wall. Is that correct?
Yes.
Okay. I have no further questions.
I guess I'm trying to figure out. He asked you to leave, right? At some point.
Yeah, he asked me to leave and then.
But what was your response to him asking you to leave?
My response was, Kara just finished playing after that he's almost asleep.
Is that the give me 30?
No, that's not the give me 30.
Okay, so when does the give me 30 come?
That was prior. That was the first time he came to the room. He didn't ask me to leave, but he was getting agitated and saying that they don't do this while I'm here. And I just told him, give me 30 minutes, I'll be done. Putting them to bed.
And so how much time had passed before that comment and then him asking you to leave?
I wasn't aware of the time I didn't see, but I feel like it wasn't 30 minutes. It was definitely less than that.
When you said give me 30, what was his response?
He said, okay, and he closed the door.
And then at some point came back?
Yes.
So when he asked you to leave at that moment, I guess my question is why didn't you leave?
Because Arthur was still awake. His eyes were closed, but he was still awake. And I knew if I were to have gotten up, that would have just like kind of reawakened him. And that's why I was like, we'll just finish him and then I'll leave. And then it was like, he's like, I was like, okay.
Okay, so that was 2 times that he's asked you to leave, because he said he asked you to leave.
Yes.
You didn't right then, right? And then he said, no, you need to leave right now.
Yes, and then after he said that, I was like, okay, fine, I'll leave. But then what I think kind of escalated the situation when I was trying to leave out of the bedroom entry door, he told me not to do that. He told me to leave.
Where was your cell phone?
I think it was in my hand at the time. Because I had it in the room with me and the kids.
Okay. And then when you exited out, did you exit out the bedroom door or the door that leads to the hallway through the bathroom?
The door that leads to the hallway through the bathroom because he was standing in front of the
I
bedroom.
didn't ask why, but that's the door you exited out of.
Yes.
How far is the stairway from that door?
I would say that. 2 steps.
Okay. And then did you head down the stairway?
No, because I didn't have my purse in the room with me when I was putting the kids to bed. It was in the kitchen area on the little countertop.
And is that on the lower level?
No, that's on the top level.
That's on the same level as the bedrooms?
Yes.
Okay. And so you said, let me get my purse. And then you went to get your purse?
I was trying to, but that's when he cut me off before I could even grab my purse. They started like pushing me more towards the stair area, where the door would lead to. Like there's a short set of stairs, like 2 or 3 steps, and then there's a long flight of stairs after that. That leads to like the door.
Did you ever get your purse?
I did once the police were there.
So prior to that, you didn't get your purse?
No.
So did you leave the building?
I went down the stairs.
Okay, so hold on a second. When you went downstairs, your purse was still upstairs?
Yes, because at the time I was on the phone with the police.
So you called the police from upstairs?
Yes, because after he let me go, I was able to call the police because I was trying to get his hands off of me, so he wouldn't push me down those stairs.
Can I ask you, if you had your cell phone with you and he wasn't letting you get your purse, why didn't you just leave? And then, as you did, call the police from outside or wherever and ask them to come so you could retrieve your purse?
Because I didn't even get that opportunity. Like once I went to the direction of my purse and he cut me off, that's when he started pushing me. And that's when the whole altercation.
No, what I'm saying is, okay, that happens. So why didn't you then turn, go down the stairway, go outside, call the police to then get your purse?
Because he was holding on to me, like he wasn't trying to let me go. I didn't have the opportunity to even like to fully even push him off of me so that I could even go downstairs. The only reason why he let go is because the children saw what he was doing. And then after that, I went downstairs. Like I called the police, I started getting downstairs, getting my stuff on, and the kids too.
So Mr. Guerin had asked you about a custodial arrangement. And so this was a school day?
It was a Tuesday night.
Okay. And so the 50-50 arrangement at the time was what?
It was, So it was like Friday evening, Saturday, Sunday. Saturday, Sunday, every other weekend. And then.
Stop.
Sorry.
When you say every other weekend
Right.
for him,
Yes, for him, it was every other weekend. I have a weekend, he has weekends, we do 2 weekends, weekends each month.
and then what happens during the weekday?
The weekday, he has them on Monday and Tuesday.
And this happened on Tuesday.
Yes.
So why do you say that was your day?
Because the way that our original agreement was laid out was that he has them until Tuesday morning, and then I pick them up in the Tuesday afternoon.
Oh, that won't work because really the agreement would talk about overnights, right?
Yes.
So who had custody that Tuesday overnight? Look at what day of the week.
Yes. I did. It was my night, but I had asked him to take care of the kids because I have class in 3, so I wouldn't be able to take care of.
So suffice it to say, despite the agreement that when you requested that of him, he was to then take care of the kids.
Yes,
And they were going to stay that Tuesday overnight.
yes.
And then again, why were you there?
Why was I there?
Yeah.
I had asked John, and then he also had asked me to pick up his target order because he ordered PS5 controllers for the kids, and I said that's fine. That would do that.
So you asked him to hang out.
So, yes.
So all of this, what time were the kids being put to bed?
I didn't get to his place closer to like 8:30, 9 o'clock-ish. I don't remember the exact time, but I know it was late.
And had you picked up the target order?
Yes,
So it was 8:39. What time was during that time the kids' bedtime?
I don't know how you guys are at current structure at his house, but mine is 7 o'clock.
Okay, were they in bed when you got to his house?
One of them wasn't. Alexander, the oldest one,
How old is he at the time?
he was about to be 6, and he's 5.
Okay.
He was 5, and he was up. He had opened the garage door for me before I even opened it.
Okay, so at some point, but I mean, they're dressed for bed.
Yes, they were dressed for men. But I had informed John to let me know if they were up because then I wouldn't have to I'm really inside because I knew that I would roll them up. He was assuring that they were in bed. Right. And so when they saw me, they're like, oh, mom's here, mom's here. So that's when I was like, oh.
Any questions based on the court's question?
None from the people you're asking.
Nor do I, thank you.
Just step in. Call their next one.
People are further with the city.
All right. Witnesses for the defense.
Your Honor, this time we would call John Reserve, please.
All right. Clerk, please come forward.
Take a seat, raise your right hand. You solemnly swear to affirm the testimony about you will be true, the whole truth, and nothing but the truth, so help you God. So have a seat. Thanks for your first and last name.
John Reserve, Jeremy Chen, R1
Inquire.
Thank you, Your Honor. Mr. Reserve, good morning. Ask you, do you remember the events that occurred, did or did not occur on September 24th, 2024 at 9:40 p.m.? Just going to ask you point blank that night, John, did you aggressively push Ms. Terrell Brennan at any time that night? Did you aggressively grab her sweatshirt, tug her sweatshirt, pull her in any way? Did you, I know it's a legal term of art, do you believe you assaulted her in any way? Were you violent towards her? Did you intend to harm her? Did you threaten to throw her down the stairs? Did you smash your own head against the wall? We're gonna talk about all that in some details. Let me ask you a couple questions about you, sir. How old are you? And at the time, I'm guessing, what, 32 or so, yes? What do you do for a living? How long have you done that? I mentioned you're also a military veteran as well. What branch? Are you still in that or no? We heard some questions about Ms. Terrell Brennan and your relationship with her. You two were never married, correct? Just very quickly, did you believe you had 2 sons with Ms. Terrell Brennan? When did that change for you?
In November.
And we heard some talk about a DNA test. Did you take a DNA test?
Yes.
Was that self-initiated?
Yes.
And did it, in your mind, prove that the oldest Alex was not your biological son?
Yes.
Had Ms. Terrell Brennan previously told you that he was?
She did.
Did she fight that he wasn't your son at that time?
She refused to believe the first test.
At the time of September of 2024, is it accurate to say the two of you had a 50-50 custody arrangement?
It is.
Heard the judge ask some questions. September 24th, do you recall if that was your night, Ms. Terrell Brennan's night, or you don't recall?
I don't know.
Okay. But were the children at your Primrose address? I asked her that Ms. Terrell Brennan had a separate apartment or separate location, yes?
Yes.
I want you, from your own perspective, to tell the judge what brought you two together that night?
We were going to have sex.
And who initiated contact?
She did.
And so was the plan to meet up after the children were asleep?
It was.
And do you recall what time she arrived?
It was approximately 8:30.
Were the boys sleeping at that point? Okay. They were in their rooms?
Yep.
And so what happens after Miss Brennan arrives?
I go downstairs to greet her. While doing that, Arthur Jonas was the one that woke up. And then she must have spoken to bed.
Okay. And I guess I'd ask you from there, did the night start to change a little bit?
After waiting for I believe that, so I want to be there.
And you said waited for what?
For her.
Okay. At any point, Mr. Rezavi, did you ask Miss Brennan to leave?
I did.
How many times would you say you asked her to leave?
Yeah. Probably at least 10 times.
Getting back into your mindset, why were you asking her, telling her to leave?
I wanted to go to bed. I was tired. I wanted to get kids to bed because it's going to be early morning.
And you said, asked her many times, did she agree?
When I told her I needed to leave, she stormed out the door. She was starting to go downstairs, turn around, she just look. I told her, I'll grab it, leave. She continued and tried to force her way through me. I held her around that. And then during that, I had my hands up and locked myself. My hands pushed down. I sang my thumb on her hoodie, at which point she yelled and probably touched me. And then she began to hit and shove me. And then I started, retreating, going back about 8 to 10 feet.
All right, lots to unpack there. We heard some conversation from her earlier that she said, give me some time, give me 30 minutes. Do you recall that statement? Okay. You said a second ago to the judge that you said, I'll get your stuff. What stuff were you going to get for her?
She had her purse. She also had a lock on that I didn't realize she had brought with. She received that. So the purse I gave to her. When she finally decided to go down the steps, I grabbed it, tossed it in a little square where the stairs changed direction for her to grab. I didn't realize she had water bottle. Police told me that it was still there, so I gave that to them and then they returned it.
All right, we can back that up a little bit. At what point did you give her the purse back?
After she was showing me, I hit my head. She called the cops and then she left. So once you got it.
Okay. Going back in time, when you say you'll get her stuff, why did you not want her coming back into the guts of the apartment?
She's taken things before. Did a ring.
Did you say a ring? Okay. And so when you tell her you'll get it, does she allow you to go get it for her at that point?
She told me to do it herself.
Okay. I want to ask you about the physical contact in very specific detail. I know I asked you this from the start, but did you sort of stop her physically by putting your hands on her?
I put my hands up. She was the one that was coming to me.
You indicated a second ago that your head hit the drywall. Can you tell the judge exactly where that occurred, how that occurred?
So I think started near the edge of the stairs. After she started pushing and shoving me, extending from there. I ended up losing my footing and my head hit the wall.
Okay. Do you recall what shoulder it was? Okay. So your right shoulder and your head, what side of your head hits the drywall? Did you do that of your own intention? Did you do that on purpose? Did you knowingly smash the side of your head into the wall? You said you lost your footing. Was that after she, you believe, touched you in some way?
Yeah, as she was in process.
I'm going to ask you about sort of damage in both respects. Did the wall become damaged? And did your head or side of your head become injured in any way?
It was red and did a
Maybe short circuiting a little bit. When the police arrived, I believe it was Officer Branch who's over my left shoulder. Did one of he or his partner take pictures of the scene?
They did.
Did you get pictures of the damage as well as to your head?
Yes.
Here I'm holding what I will mark preliminarily, if possible, as Defense Exhibit 1 or A. This is a picture that was in discovery, and I wonder if I may approach the witness with it. You may. Thank you. Mr. Resavi, I've handed you what's been marked as, for identification purposes, Defense Proposed Exhibit A as an apple. Do you recognize that picture? And can you tell me what that picture or those pictures are?
One is of my forehead, the other is
And do those pictures accurately depict what you recall them looking like, whether it be the wall or your head on September 24th, 2024?
Yes.
And is the top picture the damage to the wall?
Yes.
Had that damage been there prior to the altercation between you and Ms. Terrell? The picture of you, are you able to see any injury, redness on your head in that picture? Was that injury or redness there before the incident with Ms. Terrell? And do you believe then that those pictures accurately depict what happened to the wall and to your head that night? I'd move for admission of Defense Exhibit A.
Any objection or voir dire? Exhibit A is admitted.
Thank you. Mr. Resavi, as I sort of finish up here, I want to talk about the call to the police. Where was Ms. Brennan when she called the police?
She was in between between stairs and where I hit my head. So near the back of the door.
Did she have a cell phone with her?
She did.
I guess, some questions about, asked her how she felt. How were you feeling at that moment when she was calling the police?
I was in shock.
Shocked because of what happened? Shocked because she was calling the police, or both? Now, I asked you some questions about the police arrival. Either Officer Branch or Escobar from Pittsfield did respond to the scene, yes? Did you cooperate with them to the best of your ability? Tell them essentially everything that you could remember about the incident? And were you honest with them? Okay, and honest with the judge today? Okay, Your Honor, no further questions.
Examination.
Oh, Mr. Rice, you mentioned, am I saying that right?
It's risky.
Recipe? Recipe, okay. So you mentioned an incident in this narrative you put of someone hitting you, shoving you, you snagging your thumb on her sweater. Is that correct? Did you mention that to the police when you made the initial statement? And you mentioned also your shoulder from falling into the wall. Isn't it true that you told them that was hurt from something else previously than this incident in the body cam? Wait one moment, Your Honor.
Sir, the layout of this location, is everything upstairs?
So the garage is below. There's the door and the stairway is upstairs.
Gotcha. Okay. And was the purse in the kitchen area or where do you think, where was her purse located?
Purse was
So it wasn't in the kitchen area? Did you tell her to leave through the bathroom?
I didn't tell her specifically to leave the bathroom.
You didn't specific. What did you tell her?
I told her to leave. And she got very angry.
between the two of you, physical contact between the two of you took place in the hallway area. Is that correct?
Correct.
Were you not supposed to have the children that day? Do you recall?
I don't know.
You don't recall? All right. After this, was there then any other like family court actions or anything that occurred between the two of you?
Like March, we had front of the court hearing, and then it's March of 2025, September of 2025.
Okay, leading up to the March hearing, how was that initiated? What happened?
She initiated it after I so not being my left and mine. I was saying that's the guy words about her.
Okay, so this incident happens at the end of September. Sometime in November, there's the DNA test.
Right.
All right. After the DNA test, then within 3 to 4 months after that, you guys are back in court.
Yes.
That hearing, from your perspective, what was the purpose of that hearing?
She wanted to adjust the parenting time.
For both or for what? Adjust it from 50-50?
Yes, from 50-50 to our current arrangement, which is every other weekend. She has them.
Say again?
I have them every other weekend. She has them. First.
So she wanted it adjusted from 50-50 to basically a 65-35.
Correct, yeah.
During the course of those, you actually had a full hearing before a referee? All right. Did you have a hearing before the judge then? No. Did this case or this incident become a subject matter of that hearing at all?
I didn't know it was.
Pardon?
It was not brought up.
It was not brought up. Okay. You didn't require any medical care, meaning the hospital or anything like that, did they?
When I was arrested, I did go to the hospital when my blood pressure was.
Pardon?
I went to the hospital after being arrested, my blood pressure.
For blood pressure. So it's going to sound like a strange question. Prior to this time, to the September 24th day, were there calls like this before for you guys to get together to have sex, or? There were? Would that occur always at your house or at her place, or how would that work?
Primarily.
Pardon? Primarily at your place. And who would initiate those calls?
We would both.
Both do it.
Yes.
Okay. And on this occasion, she initiated the call.
Correct.
On those occasions, or let me ask you about this one. Was it going to be have sex and then leave, or was she going to stay the night? What typically would?
She would generally leave.
She would leave. Okay. So no further questions. Any questions based on the court's questions?
No, thank you.
All right, thank you. So you may step down. Any additional witnesses for the defense?
There are not, Your Honor. Thank you.
Your Honor, maybe
May. May be seated. All right, back on the case of people versus, say it again. Residue. All right. Closing arguments.
Your Honor, I'm going to leave this in the discretion of the court.
I was, thank you.
Court was going to take a break and contemplate the decision. I don't think that I need to. In listening to the testimony in this case, and quite frankly, the defendant is in his home. There are two children there. Mr. Rao's rendition of the facts and circumstances don't make much sense to this court as to why she didn't leave when requested to leave. He had the absolute right to ask her to leave the home. She did not leave. Also, the location of her purse, she says it was someplace else other than where the defendant says that it was. And quite frankly, I think that the testimony and credibility of the defendant far outweigh that of Ms. Terrell in terms of the events as they occurred, the timeline of what occurred, and what he was then requesting that she then leave at some point because she is there, and I got the sense, way too long. I don't believe at all that the defendant in some way started throwing himself into a wall to cause damage, which just, and I guess it could occur. I don't believe that that's what happened here. I think it was, as he stated, he lost his balance, came back, fell against the wall as there was this dispute going in. And quite frankly, given the entirety of the circumstances, it was incumbent upon Mr. Terrell to leave the premises. As indicated, it was his premises. The kids were there. She, at the point he asked her to leave, did not, and she did not. He did not. She did not have a right at that moment to then be there, regardless of what she may have thought about giving 30 and doing whatever. So for those reasons, the court would find, and I'm just be honest with you, I don't have a lot of credibility in anything that she's saying when I'm looking at her testifying and what she's telling the court. And so for those reasons, the court would find that the people have not sustained their burden and would find the defendant not guilty of these offenses. Thank you. You're not on a tether, are you, sir? No, okay. Thank you. What's today, 23rd?
Yes.
All right. Court stands in recess. Take me out.
They said they'd apply for funding, or she said that she was applying for funding. Did we receive proof that she'd applied for funding, Linda or Jennifer?
Let me check.
Did you submit your proof up here, ma'am, that you'd applied for funding? Ms. Rogers?
I didn't submit any proof because I didn't. Can you hear me?
You didn't apply for funding? What is going on today with this?
I didn't qualify for the funding.
You did not. Correct? Ma'am.
No, my bill is paid in full. I didn't qualify for the help.
Why is it the weather or what's going on here? I'm having a heck of a time connecting. She's frozen now. All right. Can you hear me all right, Ms. Rogers?
I can hear you.
All right. I'm going to give you a judgment, Mr. Morton. it'll be by default versus Shabazz and after
It's
hearing
paid.
against,
It's paid, sir.
you paid this in full?
When, yeah,
Yes, it's paid in full.
when was that, if I may ask, Your Honor, when was that payment submitted?
It was submitted yesterday. I have the receipt and everything.
Your Honor, if the court would like to hold it, was it pass this matter? I can confirm on that. I know sometimes also, depending how it was paid, I have to confirm it was cleared. But I'm working with all my numbers Friday evening, so.
It'd be nice if your apartment complex has called you and told you, so we don't have to do that. But yes, I'll pass the case.
Thank you, Your Honor.
And I will go back to Woodhaven Place versus Mark Rowland, 2600616. Just bear with me, Ms. Rogers. We're going to check on that. Where is Mr. Rowland at now?
I'm here, Your Honor.
Okay, there you are. I'm sorry. I've got all these pictures and names and faces and your name again, Mr. Rowland?
Mark Rowland.
Mr. Morton?
Your Honor, the parties have spoken. We've agreed to enter into a proposed consent judgment agreement. The terms are as follows. Rents retained, $1,707.28. Other additional costs, which are the late fees of $100. Court costs of $178.54 for a total of $1,985.82 with a payment date of March 6th, 2026, Your Honor. I know it's been a moment, but I know the court still wants to advise him, but I did advise Mr. Rowland that any agreement he enters into with me today is still not final for 3 business days. He does have 10 days regarding his right to appeal, and he did give permission for me to put his name on the proposed consent judgment agreement.
Do you agree to those terms, Mr. Rowland?
I do.
And are you authorizing Mr. Morton to sign your name to that proposed consent judgment?
I am.
And you understand that you have 3 business days to come in here and fill out a motion to set aside the judgment and 10 days to appeal since you're unrepresented by a lawyer. And also you have to pay up by the 6th or vacate. Do you understand all of that?
I do.
Any questions, sir?
Not for me.
Okay. I wish you well. Good luck to you. Thank you.
Thank you.
Would matter, Mr. Morton.
Absolutely, Your
I'm
Honor.
going to go on to something else. Kathleen Sineski versus Dylan Demmer, 2600470. Good morning, Ms. Sineski. How are you?
Your Honor,
Your name?
Kathleen Sineski.
Sir, your name? You have to unmute, Mr. Demmer.
Sorry about that. It's Dylan Demmer.
Mr. Demmer, did you listen to and understand the rights on the video?
Yes.
And do you wish to speak to a lawyer?
I'm not sure, sir. This is the first time I've dealt with anything like this. I'm not sure how the process goes. Do I need, would that be a court-appointed lawyer?
We can set you up with Lakeshore. You're entitled to do that if you'd like. And I'll ask you one other question. Do you intend to apply for funding?
In regards to what?
Financial assistance, as outlined in that video, that would help you, assist you in making a payment if you're eligible. I don't know if you're eligible or not, but.
No, sir.
Okay. You want to proceed? Look, why don't you tell me just the total amount that he owes you right now?
Right now, he owes 2 months rent, so he owes, let's see, 1595 times 2 is what, 342
1595
times 2.
You want me to do your math for you? 3190. Okay.
Okay.
And then you have a fine. What are your costs? Are there any late fees included in this?
No,
Do you charge late fees?
I do.
How much?
I have $100 of the contract.
I give $75. Is he late by 2 months?
Yes, sir.
So that's 150 in late fees. So now your total's 30. $340, and you have filing service fees. You have $110 in a filing fee, right?
Yes.
And you have how much in service fees?
About 35,000.
All right, let me see here. 3190, 50 late. And you have court costs of 35 plus 110 for 145, 30. So that should be 3290, 3340, 3485. Can you pay that, Mr. Demmer?
No, sir. There's more to the story than just that. Do I have the floor to maybe speak a couple situations?
Yeah, I don't know why you're walking around though. Why are you walking around?
Oh, I'm sorry.
I'm getting a good connection. Just stay right where you're at.
Okay.
What's the issue?
So while I was living there, Are you
living there now?
No, sir. I've been out of there since the end of January 31st.
Did you turn over the keys?
Yes, sir.
Did he turn over the keys?
In the house, left the house unlocked, turned off the power. Plus, he's still into a 6 month, he's into a year's lease, Your Honor. He just left the keys and broke the lease and left, so. Have all that damage someplace down the road too.
I had an eviction notice, sir.
Well, you didn't vacate the property if you didn't turn over the keys and remove all your property. All right?
No, sir, I had an eviction notice. I got it probably January 27th, I think it was. So I had 4 days from when I got that letter to move out. I moved out by the 31st. I left the keys, sent her a message, let her know I was out. Keys are on the counter. I'm not sure what else I was supposed to do after that point.
We were supposed to turn the keys over to her and remove all of your property. What's the issue? What's the issue? Mr. Demmer, I need you to look at me.
Okay, I'm sorry.
I need you to stop walking around. Okay. All right. Now tell me what the issues are. Why?
So the one issue that me and her never found a solution on was she has a shed in the backyard that was damaged from the roof, and she had dropped off shingles for me to repair the roof. So I took it upon myself to go to Home Depot. I bought all the materials, including wood, to replace all the wood for the shed. I did all the labor, and I ended up redoing the shed roof, and I've yet to still have any credit towards.
Did you agree to pay him to do that?
No.
Did you drop off shingles?
He said he was a roofer. He didn't pay any security deposit. I tried to work with him, so unfortunately that we got into the shed. He said he was a roofer. He could do that. He was going to show me he was going to be a better tenant. He was going to fix some screens, which I probably shouldn't have entered into that at all. But yeah, he did do that. But somewhere down the road, I'll be back again for another lawsuit for PO's final water still yet, and things that I haven't even encountered yet since he's been out. So I will probably give him some kind of credit down the road for that.
Well, here's what I think is appropriate. I'll give you a possession judgment for the
I think it's breaking out. I can't hear nothing.
Well, I'm thinking.
I couldn't hear that last part, sir. I'm sorry.
All right. Let me just think it through for 1 second.
I think the audio was going in and out for a second.
No, I get it. Let me just.
Okay, I
just
hear
want
you
to
now.
think. I just want to think things through for a second. Okay.
Okay, thank you.
So, what other damage items do you want? Are you claiming? You don't know what the water is or anything?
I don't have a final water bill yet. Final water bill, he left a trampoline on the property, which I have to have hauled away. He left some garbage out at the curb, which was all smashed up. I had to pay somebody. I haven't even done final damage. I haven't even re-rented the house yet, so I still have all that damage. He just walked out on the year's lease.
Oh, geez, you made a big mistake. You got a year's written lease with him?
Yes,
You made a big mistake, Mr. Demmer.
I explained that to him.
You're going to be on the hook for a lot of money here until she can re-rent the property.
Well, if I can continue, if I could explain myself a little further.
Go ahead.
So the house, when I first got the house, I was in a very tight pickle, seeking somewhere to live closer to my son's school. That place was right down the street. I got hooked onto the thought of it, and me and her kind of rushed ourselves into this situation. The house wasn't ready for me to live in by any means. It smelled like absolute urine from top to bottom. And yet I made continuous statements about that and nothing was done about it. But when I got the keys, it took me about 2 weeks to air out the house and finally move my stuff in.
Did you move in?
It was got the keys, I think it was end of July or so it was
wait a
about
minute. So you lived in there for 6-7 months, right? You went, you walked through the property before you agreed to rent it, right?
Correct.
Did you smell the urine then?
Yes, sir.
Well, you still chose to rent it then, didn't you?
Correct. Yes, sir.
Well, what's the issue then? I don't understand.
So when we first signed the
Wait a
contract,
minute. I'm just trying to think of how I'm going to proceed with this. You've created a mess. You don't get to just leave the property.
I tried to make several statements to her in regards to having troubles with the house and affording it. I told her the house, there was a point in time in the beginning of January, end of December, the house was full of mice poop. I had to throw out several belongings. Every room, every closet was full of mouse poop. I had to throw out shoes, clothing.
When was this?
It was beginning of July, end of December.
You went through the property. You didn't see any of that before you agreed to rent it?
This is while I was living there, sir.
He moved in, he signed the lease June 23rd.
Which I didn't get a copy of for about 40 days later.
And you sound like a whiner now. I don't want to talk about not getting the lease copy. Okay, please.
I mean, I got a copy that was not what I signed. After I signed it, I didn't get a copy till about a month later, and there was new handwritten comments on that copy, which I never signed off on. She took our signed copy, we went on with life for about a month. She seen how it goes. She wrote in some statements regarding appliances, and then I got my copy. I have text from her stating how much the recent water bill was, which I paid. And now in the court paper, it's a $20 difference of what she's telling me in the text. Nothing she said since day one has lined up with what she's been telling me. She's not a good landlord. So therefore, I tried texting her about not being able to afford it, this and that. And she acted like she was in okay with the situation. This was in the beginning of January. And I have several texts from her asking me, what's your situation? Hey, Dylan, just wondering what the situation is in regards to moving, blah, blah, blah. Nothing in there. In the first 3 weeks of January, we had several conversations. Not one of them did she tell me I'm filing an eviction notice. I'm filing an eviction notice. She had that ready.
All right. Okay, Mr. Jammer.
Your Honor, he kept mentioning he was moving out. He was having a hard time. I told him he had to put something in writing so I knew what was going on. He stated,
I'm going to set this for trial on the issue of money damages. does he have any property here? In the property now? You said
He's got a trampoline
Right.
outside.
You want the trampoline?
No, sir. I'm not concerned about the trampoline. No, sir.
Does he have anything else in the property now?
No.
All right, so. And you agree to relinquish the property. You have no claim in the property right now, correct? Is that true?
Yeah, you're speaking to me, sir?
Yeah, I mean, I'm gonna set it for trial on.
Yeah, I have, if you're asking me if I have anything to do with, I have no ties to the house as of right now besides this.
You went in and got the keys?
Finally did, yeah. Then he told me to turn the power off, so I have it where DTE switches my name, but he wouldn't turn the furnace off, so I went in there, it was like 49 degrees.
Why would you do such a thing? Did you do that?
So like I said
I'm
before.
asking you a question. Did you do that?
Yes, sir. I'm not sure what else I was supposed to do. I don't know.
Just turn the heat down and let the pipes freeze. Is that what you thought was funny or?
No, sir. No, sir. I'm not here to bash anyone, hurt anyone any further. I'm not here for any of that. And I had no intentions of that. I asked my mother what she thought I should do. I don't have much support. I didn't know what to do. I've never dealt with a situation like this. And my understanding in my mind right now, I don't think that Miss Kathy likes me or has liked me, or I haven't approved of her attitude toward, I didn't want much conversation. I didn't want much as I wanted at least as the least conversation between me and her until we had this figured out. I didn't do that to hurt anyone.
What do you want to do? You want me to set this for trial on the issue of damages, or do you want to refile when you get everything together?
No, you can set it for a trial, I guess, because he's already here, then they gotta sue him again.
Yeah, we'll set it for trial on the issue of money damages. Let's set it a month out. And prepare a dismissal order of the landlord-tenant case. And if you would, Jennifer or Linda, and just say parties agree that defendant has now vacated and relinquished possession of the property to plaintiff. That's on the terminate or the non-payment of rent. So we can just do a dismissal order on that. And you agree that you've relinquished the property, correct, Mr. Demmer?
Yes.
And you do as well, that he has, correct?
Yes.
So prepare a dismissal order on the possession claim and indicate that on the dismissal order. And then we're setting this for trial on the issue of money damages. We're going to set it out for a month or so.
Would April 6th at 9:30 be okay?
Is that good with everybody?
Yes.
Is that good with you?
Sounds great.
April 6th at 9:30 will be your date. Do you have a place where we can send you mail and notices, sir?
Yes, sir.
Give me the address.
1722 Riverbank. That's one word. In Lincoln Park, Michigan.
Remind me, what's the zip there again?
48146.
All right, so we'll write that down though. April 6th, you're going to be here at 9:30, okay?
No, will that be Zoom too, or?
No, you got to show up in person for a trial.
Okay, and if I just may ask one quick question, sir.
Sure.
Now, you've mentioned that I would be responsible to the end of the lease.
I'm not gonna I can't give you advice. I'll look at.
No, it's just a question in regards to if I'm evicted, how would that?
I'm gonna listen. We're gonna have the trial on April 6th. Go talk to a lawyer. Okay?
Can I get assistance with that?
I can't appoint lawyers. You can go talk to somebody at Lakeshore. They'll chat with you and tell you the phone number, and you can call them.
Judge,
But
if
they're
I
not-
may. Yeah, Mr. Demmer, I can take you into a breakout room and I can give you the phone number for Lakeshore Legal Aid.
Okay,
thank you so
But
much.
They're not
Thank
going to
you.
come to court and represent you. Is the point?
No, I just got a few questions about all this. I've never
Talk
dealt
to
with
them.
it.
Talk
Okay.
to them. Okay.
Thank you.
Have a good day. Thanks.
You too.
Thank you. Bye now.
Thank you.
You're all set. Michigan Foreclosure Solution versus All Occupants 2600515.
Good morning, Judge Cohen Geisler, P69024, standing for Paul Spindler.
I'm sorry. I don't see where you are.
I'm here.
I'm sorry. Okay. What is this?
I'm standing in for Paul on this case. I'm on here on behalf of the plaintiff.
Okay. Is anybody here that is an occupant of the property there? At 22401 Monterey Drive in Woodhaven?
I'm pretty sure there's nobody that checked in for that property, Your Honor.
Okay, so when was the sheriff's sale, and has there been did the redemption period pass?
Yes, it has passed, sir.
And you're not looking to, so this isn't one of these that I'm getting lately where somebody's coming in saying they vacated because they drove by once and there's no car in the driveway, is there?
No, sir.
I mean, it's the most ridiculous, nonsensical garbage. All right, you're entitled to possession. So default judgment entered. Occupants failed to appear. March the 5th, okay, will be the writ day.
Thank you, sir. Good to see you. Have a great week.
You too, Mr. Geisler. You're going to submit your order today, right?
E-file. Yes, sir.
Thank you. Thank you.
All right, be well. Thanks.
All right, now what do I have? Do I have Deerfield versus Castillo? Deerfield versus Castillo?
Daniel Landman, Your Honor, on behalf of Deerfield.
2600528. Is Castillo here, Emilio?
I do not have a Castillo that checked in.
Counsel, you paid for a second mailing, right? Yes, I'll give you a default judgment.
Thank you, Your Honor. The breakdown is as follows. Rent to retain is $2,310. There are 4 late charges at $45 a month for a total of $180. There's $359.32 in water, sewer, and trash. And then there's a credit of $1,269.66 in payments, resulting in a balance of $1,579.66 plus costs of $187.07 for a total of $1,766.73.
Default judgment will enter in that amount. The writ date will be March the 5th. I will ask you to submit that by e-filing today.
We will do that.
For the record, defendant failed to appear. It was scheduled for 9:30. It's now 10:16. All right. I think you're all set, right?
No, Your Honor. I have several cases at 9:30 for Granite Tele Valley.
Jeez. All right. Mr. Morton, are you done?
Yes, I am, Your Honor.
You're all done? You're just watching?
No, sorry, Your Honor. I said all done. I spoke to my client on Tanglewood versus Shabazz 26-0022. Was it 8?
Tanglewood versus Shabazz 2600228. All right, Mr. Morton. I'm sorry. Your name again?
For the record, Attorney Ian Morton on behalf of Tanglewood.
And where is the defendant, Ms. Shabazz?
We have the occupant present.
It's
Jamie
actually Ms. Rogers, Jamie Rogers. Start your video. State your name again, ma'am.
Jamie Rogers.
You got to start your video. I can't. There you are. All right, what did you find out, Mr.
Your
Morgan?
Honor, I spoke to my client. They did confirm that the payment did come through the electronic system, but since it was just paid yesterday, it didn't clear. I asked the matter was it adjourned? I anticipate it's going to be dismissed by Wednesday. So if you want, whatever the next available date is, we'd set it for that. And then like I said, I anticipate a dismissal coming into the court no later than Wednesday.
Give me my next landlord tenant day.
March 2nd. We could do 9 o'clock.
At 9 a.m., okay?
Perfect.
So, Ms. Rogers, you understand what he said, right? He's got to make sure that the check clears or whatever you paid by, it goes through, and then he's going to move to dismiss. In the meantime, I'm adjourning till March the 2nd at 9, okay?
Okay, thank you.
Thank you very much. Have a good day.
And thank you, Your Honor. That is the last matter I have before the court today.
Thank you. Mr. Landman, are these going to be more the water, sewer, lot rent?
Your Honor, these are all first hearings, and I do see, I think out of 5 cases, at least 4 tenants present.
All right. You want to go into a breakout room with them and talk to them and see if you can resolve it with them?
Well, I'm wondering whether any or all have applied for assistance.
Let me call them. Granite Televelli versus Celia Elmore, 2600518. Is she here?
She is.
Folks, when I call your name, just jump on, please. I don't want to have to keep repeating that we have to start our videos. I don't really care to do that anymore today. Ms. Elmore, I need you to start your video, so I'll do it again. I'm taking a 5-minute recess. These people got to be ready to go. I'm not going to wait. Jeez.
Your Honor.
What?
I'm sorry to interrupt, but the Michigan foreclosure with Mr. Geisler.
Yeah.
The defendant was here, but all I have on the docket is all occupants, and he was out in your courtroom, but he never responded.
All right. It's not your fault.
I'm sorry.
You're fine.
You can go take your recess.
Call back Mr. Geisler and tell him to log back in.
I will. And the defendant is logging back in too, because he just called here.
Yeah, that's what I want. So tell them when they come back on. Where is Celia Elmore? I mean, I don't know why anybody Zooms if they don't know how to Zoom. I mean, where'd she go?
She was in there and
I know she was. Now she's disappeared.
she's gone again.
You do have, Your Honor, Ms. Smith, Ms. Woolsey. Those 2 are here. And
I need to get off. I don't mind that make people wait, but I need to get off here for 5 minutes. I'm getting agitated. Thank you.
All right, I'm gonna get back to
Unmute, tell me your name.
Current rent to retain is $1,326. There's 2 late fees at $35 a month for a total of $70. There's utilities of $218.90 for a grand total of $1,614.90 plus cost of $231.82 for a grand total of $1,846.72. Proposed writ date is March 5th.
All right, you can go ahead and submit your judgment to that effect.
Get back in.
Okay, thanks. Granite Televelli versus Danetta Smith, 2600523.
Daniel Landsman for the plaintiff. Ms. Smith is present.
Ma'am, your name?
Danita Smith.
Where are you? Jeez, oh, Pete. Okay, there you are. I'm sorry. Did you listen to and understand the rights, ma'am?
Yes.
You wish to speak to a lawyer or apply for funding?
No, I do have a question. I'm no longer there, but I haven't returned the keys or anything. But I was wondering, can we select a payment arrangement or something like that? Or how does that work?
Well, you're still there.
Right, because I
As far
haven't
as
returned the
we're
keys.
concerned, if you haven't turned over a key.
Right.
Why is Miss Bryant? What's going on, Miss Bryant? You unmute, tell me your name.
Suzanne Bryant, manager, Tele Valley. Miss Smith owns her home. She's not a renter.
Oh. Okay. Mr. Landman, why don't we proceed here? I didn't realize that. What do you want to do, Mr. Landman?
Your Honor, I'd still like to obtain a possession judgment. That way, if the tenant has not made other arrangements for her home within the statutory time period, my client would be able to move the home off site.
Yeah, I get it. Okay. Go ahead and proceed.
Thank you, Your Honor. Rent to retain is $1,338. There are 2 late fees at $35 a month for a total of $70. Utilities of $77.25 for a total of $1,485.25, plus costs of $191.11 for a grand total of $1,676.36. And Your Honor, we are requesting only a possession judgment.
All right. You going to pay that rent? You're going to be able to pay that, right, ma'am?
Yeah, if we can do an arrangement that I can pay monthly or however you guys want to do it, I would like to do an arrangement. I can't pay that all in one time, no. But I can pay over time, yes.
Mr. Landman, do you want to go into a breakout room with her or tell her what you're willing to do now?
I think, Your Honor, the best solution is to get the judgment entered, but Ms. Smith is certainly welcome to talk to Ms. Bryant and either work out a payment arrangement or perhaps an arrangement to sign over the home in exchange for a waiver of the lot rent.
Do you have equity in that mobile home, ma'am?
What's the equity? I'm sorry.
Well, how much is the home worth and how much do you owe?
I don't know how much is worth. I don't know. I just been paying lot rent, so I don't know about all that information.
I'm just curious. Why did you move out?
Well, it's too far from my job. I wanted something closer, and I'm sorry I didn't let the owner know that I was moving out or anything. I didn't return the key. I do apologize about that. I didn't communicate that with them. But again, I'm willing to pay whatever I owe if we can have an arrangement and talk about it, if possible.
I think the problem, Your Honor, is that rent would continue to accrue as long as that home is there. I think the better solution, Ms. Smith, if I can't give you legal advice, but I think if you talk to Ms. Bryant, it may be possible for you to sign off on your home. And they would then waive the balance that you owe, and you would sign off on the title. You do have title to the home, do you not?
I do, yes.
You need to figure out if you have equity. How much? I mean, is it owned free and clear? Do you still have a note on that, or what?
I don't have a note or anything that's owed on it. No.
Well, you should have some equity in it. I mean,
it's a pretty old mobile home. It needs a lot of work done to it. I tried to sell it. I was thinking about selling it. No one wants that home. So I tried. It's pretty old. So
I give them a writ date of March the 5th. I'll make it March the 7th. And the amount to be paid to save it is $1,676.36. I'll let you talk to Ms. Bryant, but you're going to lose that property if you don't do something quick, okay? So I'd encourage you to go over there and talk to her. Have a great day. Thank you.
Thank you.
Celaya Elmore, is she back? All right, Granite Tell Valley versus Celaya Elmore, 2600518. Miss Elmore, your name? Got to unmute, ma'am.
Yes, Swalia Elmore.
I'm here. I apologize.
Mr. Landman,
Daniel Landman appearing on behalf of the plaintiff.
did you listen to and understand the rights, ma'am?
Yes, I listened to it.
All right. Do you intend to speak to a lawyer or apply for funding?
I applied for funding through my job. I tried to apply through funding through the state and I wasn't approved.
You were approved or were not?
We're not approved for DHS.
All right. So, okay. Mr.
But I
Landman,
applied through my job, so that's going to take a couple of days is what they said to see if I get approved or not. But I'm looking to try to just pay it off, seeing that when I get my my taxes to come through, but because I can't pay what is due all at once with the paychecks I'm getting right now. I kind of just fell behind. And
let me listen to Mr. Landman. Tell me what is owed, sir.
Your Honor, rent to retain is $3,006.54. Utilities are $719.65. There are 3 late charges at $35 a month for a total of $105. That total is $3831.19 minus payments of $883, leaving a net of $2,948.19 plus costs of $191.11 for a total of $3139.30.
All right, man, that's a lot of money. I can give you until the 7th to pay up. But that's going to be the writ date, okay?
okay,
So you have to pay up or vacate by then.
okay,
All right, so I'm going to give them a judgment, man amount 3139.30, and the writ date, let's make the 7th, counsel, okay?
Very well, Your Honor.
Oh, wait a minute, not the 7th, the 6th, the 6th. Sorry. Okay, good luck to you, ma'am.
okay. Thank you.
Granite versus Shannon Allen Woolsey, 2600524.
Daniel Landman for the plaintiff, and Ms. Woolsey I did see earlier. She is present.
Yes, I'm here.
Your name, ma'am?
Jessica Woolsey.
Did you listen to and understand the rights on the video?
Yes.
Do you wish to apply for funding or speak to a lawyer?
My CPS worker did apply for funding. I'm waiting to hear back from him. He did that about like a week and a half ago, and I do not need to see an attorney. I have most of the money together. We're just trying to see what's going on with that, or if I have to get the rest of it together.
You have to provide proof that you made an application for funding. You have to provide proof of that to this court this week, and I'm adjourning it to March the 9th at 9:15. How's that?
Okay, thank you.
Thank you very much. Now I've got, are we done or I got Megan?
You're rid of me, Your Honor. We're all set. Have a great day.
Hey, you too. Thanks a lot. Michigan Foreclosure Solutions versus all occupants with respect to the property at 22401 Monterey in Woodhaven, 2600515. Mr. Geisler, are you on? Did you guys get a hold of Colin Geisler?
Judge, we did, and he's been here 2 times, and I've admitted him twice, and now he's gone again. And I do apologize because he has been here, and I've admitted him twice. Let's see.
The occupant.
That'd be Mr. Griffer.
All right. Well, can you call him again and tell him to get on here?
Yes, Judge.
Thank you. Williamsburg Square versus Stephen Theo and Brittany Angle, 2600159. Did you guys resolve this yet? You did? Give me a judgment on this Butler and Robertson case down here, will you please? Just give me a judgment and I'll fill it out.
Yes, Judge.
All right. Where is Mr. Tao, your name?
My full name, Your Honor, is Steve Tao.
Ms. Angle, your name?
Brittany Angle.
Judge, I have Mr. Smith here for Freeman's office. He is currently in a breakout room with another defendant. Would you like to wait a few moments? I do
What I'd like
have,
to do is start requiring everybody to come in person. I'm really getting agitated with this nonsense.
I do have Mr. Kasar here with his tenant and they are ready to go. And that is at 10:30. However, they are ready to go.
Well, he's going to have to come out of the breakout room. I'm not going to wait for him to do all
That's
these.
fine, Judge. I'm going to go get him.
Marsh Creek. Let me take Marsh Creek and let him stay in there for a minute. But he's coming out when I do these Marsh Creek ones. Marsh Creek versus Daja Thomas, 2600226. Who has Marsh Creek?
I'm bringing him in, Your Honor.
Brittany?
Who's here from Marsh Creek?
Renee Johnson.
No, I know, but the lawyer, who's got the lawyer? Okay,
That would be
go
me.
ahead, Ms. Haddad. Your appearance?
Yes, good morning, Rania Haddad, P84927 for the plaintiff.
And do I have Deja Thomas here?
Yes, we're here.
I need people to start their video. I'm telling you, I'm getting really agitated. It's not that hard. Your name, ma'am?
Deja Thomas.
Any resolution on this, Ms. Haddad? What are you asking for? There was a balance of 3456 last time, and we adjourned it. You guys were applying for funding. Did you hear from the funding agency?
The worker denied the request. She said she did not receive my uploads and I had to reapply. But at the end of the week, Saturday, I get paid. I'll be able to pay the balance. And I did pay $1,400 dollars towards that balance, which I owe like $2,101 right now. $1,400 and something dollars.
That's true, Ms. Haddad?
Your Honor, I'm showing that there's still a balance of $1,902. That does not include $170 in attorney fees and costs. So the total redemptive amount as of today is $2,072. I'm going to double check the ledger, Your Honor, to see if the payment that she refers to has been, is the payment.
Ms. Thomas, do you think you owe $2,072?
Yes.
I'm not sure why Ms. Grant's there. Are you?
I'm on a lease.
Oh, you are? Okay.
Mm-hmm.
Okay. I'm
mother.
sorry, Ms. Grant. I didn't ask you your name.
Shantique Grant. I'm the mother. That's my daughter.
I see. And Daja Thomas is the daughter.
Yes, sir. Yes,
Oh,
Judge.
all right. Okay. Okay. So, Mr. Smith, if you want to go in and talk to some people for a couple of minutes, I'm good with that.
Thank you,
I'm fine
Ron.
with that. You tell them who you want. I'm going to go through Marsh Creek. It just seems like I'm moving at a snail's pace today.
I'll be ready
So-
for you, Your Honor. I'm ready to move.
Okay, take them and move them, will you please?
Thank
All
you.
right, so what do you guys want to do? Can you pay this judgment amount of $2,072?
I can. I get paid Saturday, and my taxes is supposed to come Wednesday. But for sure, Saturday when I get paid, I'll be able to pay the full balance. And plus, I have money I haven't put into the money order yet that I plan on paying towards the that debt also.
What do you want to do, Ms. Haddad?
Your Honor, in that case, if the defendant is willing to enter into a consent judgment today, allowing her to pay that balance off or vacate by 3/5/2026, that would be our request. There's no money judgment requested or entered.
Okay, so. I'm going to let you go in a breakout. I'm going to let you guys go in breakout rooms with these people. Because I don't want to have to explain everything to everybody all the time. I'll let you go in there. You guys can figure out.
Listening to it, so I had to call the courtroom.
Mr. Griffer.
Yes, sir.
I could hear you.
Oh, I'm sorry about that. I didn't know I was muted.
All right. Well, I'll let you go into a breakout room, Ms. Haddad, with whoever's on your docket.
Thank you, Judge.
Okay. Now, let's go to where is Michigan Foreclosure Solution versus all occupants 2600515. Mr. Griffer, your name?
Kenneth Grifford.
Colin Geis on behalf of the plaintiff. Thank you, Judge.
So I called the case. We didn't realize he was here.
Okay.
Because it's only all occupants. Do you have a defense here, Mr. Griffer?
They had me in Judge Heston's courtroom. It got dismissed. I thought it was over with. Then I got a court.
Dismissed.
This whole case got dismissed in Judge Heston's courtroom.
Oh.
And then I got a summons to appear in your courtroom instead under a different attorney's name for the same case. I thought it was over with. It's actually my grandmother's house. She's in Aberdeen Rehabilitation Center because she had a stroke. I'm trying to represent her as best as I can. Then they said this thing about Lakeshore Legal Aid and whatnot.
Slow down. Slow down.
What was that? Sorry about that.
Time out. Can you pull that up, the civil, on my screen, Sadie? I don't know how it could have gotten dismissed. Do you know anything about that, Mr. Geisler, in front of Judge Heston?
No, Judge. I'm trying to look it up myself real quick. I reached out to lead counsel to see if he knew.
Now,
Judge, if I may, what was the case in Judge Heston's courtroom, Mr. Griffer? Was that under your grandmother's name?
I believe at first it was Emily and David Griffer. Then it was all occupants.
Oh, I see it. I think it's 2503609 LT.
And it got dismissed. I thought it was over with.
Slow down. I need to see that file.
It was dismissed without prejudice, Judge, on November 12th.
The case number?
What's the case number again?
It's 2503609 LT.
0369. Is that what he said?
2503609.
Good.
Want me to go to the end?
Yeah.
Judge, we're printing the file now for you and bringing it down.
It looks like the case was dismissed by the plaintiff without prejudice.
Yeah, from talking to lead counsel, it looks like maybe that original file, Judge, was filed premature and the redemption period hadn't run yet. From looking at the deed, it looks like the deed was issued on July 31st of 2025. And in a previous case, it looks like was originally filed September 5th. So I think that may have been the issue on that one.
What are they trying to, is this one of those where they're saying basically, I drove by there and there's no cars in the driveway and therefore we're entitled to immediate possession? I hate those. Why are they filing in September if the redemption period is only 35 days old? I mean, I understand the confusion. There's nothing I can do for you, Mr. Griffer.
What do you mean?
The property needed to be redeemed.
Yeah, the redemption expired on January 31st, Judge.
So, I mean, the fact that it was dismissed by Judge Heston without prejudice because it was filed untimely, in other words, filed too early, that has no effect here. Somebody needed to redeem that property by January 31.
I was unaware. I just thought it was over with. I tried getting a legal aid through Lakeshore when I was in with Miss Heston, and then when it got, or Judge Heston, when it got dismissed, I thought the case was over with. I had Adam Devlin trying to buy the equity out of my house, saying that we had $30,000 or something like that in equity, and I didn't understand it. I was in the process of getting a power of attorney so I could speak for my grandmother, and when they said they dropped it in Judge Heston's courtroom, I'm trying to get her out of rehabilitation and everything, get her back on her feet. And I thought it was over with, so I didn't have to deal with it until I got this new paperwork appearing in front of you.
You need to talk to lawyers, not make assumptions.
Right. Well, I thought it was over with. I didn't know I needed an attorney or anything.
Well, wait a minute.
I had no idea.
Did you not know that your mother lost, or your grandmother, I'm sorry, lost the property on foreclosure?
Well, the mortgage company that was running it, I have them being investigated for a mortgage fraud. I turned them into the FBI because they did some fraudulent practices. And in fact, when I was in Heston's courtroom, Adam Devlin even told me that it was a predatory loan. I even believe I know who's behind the loan. And I went to the FBI for it. I didn't go in person because my cars broke down. I was contacting them through the FBI tip line on the internet. And it's my intentions to go to the FBI now in person and talk to them because I thought it was already resolved. I wasn't that worried about when they dismissed it in Judge Heston's courtroom. I said, okay, I got some breathing room. It's taken care of. I don't have to worry about reappearing in court. I can worry more about my grandmother and getting her back, hopefully in health, and then getting her back home where she belongs. I thought I handled it properly. And the next thing I know, I'm getting a court summons.
Is Michigan foreclosure the one that does file for these early files under the statute asking for immediate possession because either somebody doesn't live there or are they the ones that do that, Mr. Geisler?
I'm not sure, Judge. I'm covering this for Mr. Spaniello. He's on vacation. So I this is not my client, and I'm not familiar with the way they practice. I just looked at the document. I see the deed is valid, the timing is valid, and the case was properly filed. So we're before Your Honor on this one.
So the last hearing note just is the topic.
Yeah, it's fair to permit inspection after foreclosure. I hate these. I just hate these.
That was the previous case, sir.
No, I know. I know. I just get the feeling they buy these properties if this is the company that I'm thinking about. And then they can't wait to get their hands on them. Like they don't think there's a redemption period.
Yeah, that had me all kinds of confused. I can't afford an attorney right now. Like I said, I lost my job because my cars broke down and whatnot. And when it got dismissed, I just thought that was the end of it. So I'm like, okay, I don't need to seek a power of attorney.
You shouldn't reach conclusions about something that you don't know about, sir.
Well, when Judge Hudson told me that it was dismissed, I just automatically presumed it was thrown out of court and I was good to go.
My father had a saying about what happens when we make assumptions.
Oh, no.
You can't make assumptions, sir. You're not a lawyer. You needed to talk to a lawyer.
I just presumed when it was dismissed from Judge Hudson.
I know. You assumed, presumed. I get it. You got yourself in some problems now. Nobody redeemed the property timely. That's the problem. Oh, boy. right, you're David Grifford Jr., right?
No, sir. David.
Oh, no,
David. Sorry,
Huh?
David Grifford Jr. is my uncle. He lives in Flat Rock. I'm Kenneth Burgos.
This is just nonsense. I hate these. Notice of purchaser's right to inspect sent and inspection refused. Notice attached. I'm not going to give you a judgment today. But I don't know how you're going to resolve this, Mr. Griffith, but you gotta talk to a lawyer. Okay?
Can I get some kind of legal aid through Lakeshore?
You can call up Lakeshore, and I hate to do this to you, but you know what? I think in some ways, Michigan, whatever these characters, Michigan Foreclosure Solution has created their own problems here. Inspection refused. They can't wait to they think there's no redemption period. I'm adjourning this 2 weeks. You can talk to a lawyer. They'll chat with you. I'm going to take it to March the 9th. At what time?
How about 9:30?
At 9:30. Yeah, if they see my name on these, I really hope they won't bring me any of those inspection things. Mr. Geisler, will you please tell Mr. Spaniola there?
Sure.
I don't know, that's what they buy it at the foreclosure sale and they can't wait to get their hands on it. We still have laws here in this country.
Understood.
Some of us try to
that was the previous case, sir. That was not us. That was the previous case.
I know. I'm not.
Okay.
Listen, I'm not. I get it. You weren't here. You're just the fill-in guy. Yeah. I get it. I'm just telling you, I don't like them. And that's just, I'm talking about. Yeah.
Understood, sir. I understand.
March the 9th, sir. March the 9th. Okay.
9:30
You got. They're going to chat with you. They're going to tell you where to go. All right.
All right. Thank you.
They're going to tell you where you can call. Thank you.
Yeah,
March
thank you,
3 versus Deja Thomas. Are you guys ready on that?
Yes.
2600226, and that is Deja Thomas and Shantique Grant. I'm sorry.
It's okay.
All right, Ms. Haddad, did you talk to these young ladies on this case?
I did, Your Honor. We do have a resolution.
Okay, can you state your appearance again and tell me what the resolution is?
Absolutely, Judge. Rania Haddad, P84927 for the plaintiff. The parties have entered into a consent judgment today. This is a consent judgment for possession only. Rent to retain is $1,902. Attorney fees and costs of $170 for a total redemptive amount of $2,072. The defendants have agreed to either pay the balance off or vacate by 3/5/2026. I did advise of MCR 4.201J, the 3-day rescission rule, as well as a 10-day appeal date. Ms. Thomas has given me permission to sign and submit this on her behalf today. I did indicate that although there's a monetary amount, this is a possession judgment only, so it isn't an either or. They have to either pay or vacate by that date. And they do understand the terms, Your Honor. So that is how we've opted to resolve the case.
Ms. Grant is saying that she's on the lease as well. Did you require her permission to sign her name to this proposed consent judgment?
I did not, because she's not a named defendant, but I can ask her for her permission. Ms. Grant, do I have your permission to sign and submit your name as well, since you are an occupant and you are on the lease?
Absolutely.
Okay, let me just make sure that I have the correct spelling of your name. Is it the way that it is spelled on?
CHANTIQUE. Grant, GRANT.
Okay.
How much are your late fees, Ms. Haddad? I'm going to ask you to break those down in the future.
Okay, Your Honor.
Rent to retain is how much?
Let me take a look at the ledger here. It is, all right. It looks like it is rent is $1,518. There is late charges of, let me take a look. It looks like it is $100 late fees.
Per month?
But I believe that there was a credit given, a $30 credit given for the late fees.
I don't know, but that's a heck of a way from 1910 or whatever you said. How many late fees did they have?
It's two late fees, Judge. And then there's also pet fees in the amount of $35 per month. There's a utility as well.
How much
Water.
are they charging a month for late fees?
Late fee is $100 a month.
Okay, well, I only give 75, so they got to reduce those.
So it's 100 and then 100. So looks like they did give a credit of $30. I mean, that's not, let me see. So that's,
These guys aren't sitting out there, right?
okay. So they've already given a $30 credit, Your Honor. So I can give the remaining credit. So I can give the remaining, it looks like they gave a $30 credit for late fees. So I will give an additional, $20 credit for the late fees. And I'll indicate for future reference that late fees are capped at $75.
Yeah, they know that. They've been knowing that I've been only doing, it was 50 until I raised it about maybe 8 months ago. So that's why I always require lawyers to tell me the rent to retain then the late fees.
Noted, Judge. I will do that.
Even though the apartment complexes know of it, they just still put them on there and
Understood, Judge. I'm going to reduce it by an additional $20. So if you would like me to restate the totals, I can do that. So it'd be 1902 minus the 20. So then the new totals, Your Honor, would be $1,882 in rent to retain. That does include the late fees, plus $170 for attorney fees and costs. So the total, Your Honor, would be reduced by $20. So $2,052 would be the number on the consent judgment.
All right. And she has your permission to sign your name, right, Ms. Thomas, to that?
Yes.
Ms. Grant?
Yes.
And so you understand and agree that you have to pay $2,052 no later than March the 5th, or you have to vacate. You understand that?
Yes.
Do you, Ms. Grant?
Yes.
You have 3 business days to come in here and fill out a motion to set aside the judgment, 10 days to appeal. Do you understand that?
Yes.
All right, so this will be a judgment, consent judgment, writ date March 5th. I'll ask you to send that one over. If you want to talk to these others, I've had these criminal cases sitting here too that I haven't even gotten to yet.
I did speak with Ms. Johnson. The only one that I haven't spoken to is Ms. Norwood. If she's present, I can speak to her.
Okay, so you
Ms. Norwood did not check in with us, Judge.
He's on the phone with them in custody. He said he'll come in and do them all.
Marsh Creek versus Jada Norwood. Let's call that 2600232. Is Ms. Norwood? It looks like she's not here, right?
No, Judge, she did not check in.
All right, so I'll give you a default judgment on this. Just give me the breakdown, please.
The breakdown is as follows: $4,911 in rent to retain, plus $170 in attorney fees and costs, totaling $5,000.
Wait. I want you to give me the breakdown: rent to retain and then late fees.
So, yeah, sorry, Judge, they didn't tell me that. So that's why
That's okay,
I can tell you that for this one, they do have indicated on the ledger that they credited $90 for the late fees. So that would be $300. So that is okay. So we're showing rent to retain in the amount of $4,701. The late fees are $210.
What's that? 70 a month?
That is $70 a month, yes, for 3 months.
Okay.
And then the attorney fees and costs are $170. So the total redemptive amount would be $5,081.
All right. Defendant failed to appear default judgment, writ date March the 5th. The amount to be paid to save it is $5,081. Marsh Creek versus Shanae Johnson, 2600-236.
Good morning, Rania Haddad for the plaintiff.
You guys are all set, Ms. Grant and Ms. Thomas. Good luck.
All right, thank you.
Shanae Johnson, your name?
Yeah, Shanae Johnson, Shanae Kiera Johnson.
All right. Did you two talk? Is there a resolution on this one?
Yes, Judge, we do have a consent judgment today. This is a consent judgment for possession only. Rent to retain is $3,973. Late fees in the amount of $210. That would be $70 a month times 3 months. Attorney fees and costs of $170 for a total redemptive amount of $4,353. Defendant has agreed to either pay that balance off or vacate by March 5th, 2026. No money judgment is entered today. I did advise of MCR 4.201J, the 3-day rescission rule, as well as a 10-day appeal date. Defendant, Ms. Johnson, has given me permission to sign and submit this on her behalf today.
Do you agree to those terms, Ms. Johnson?
Yes.
Do you understand you have 3 business days to come in here and fill out a motion to set aside the judgment? You have 10 days to appeal?
Yes.
So you understand you have to pay that amount of 4,353 no later than the 5th of March, or else you have to vacate. And if you don't do either one of those things, you're going to be evicted. Do you understand that, ma'am?
Yes.
All right. Do you have any questions?
No.
I wish you well. Good luck.
Thank
and do you have any more with me, Ms. Haddad?
I don't believe so, Judge. Everyone have a wonderful day. Thank you.
Have a great day. Thank you. All right. You've been patient, Mr. Smith. Let's start with Tanglewood versus Brittany Austin White, 2600-350.
Good morning, Your Honor. Andrew Smith, appearing on behalf of the Tanglewood Apartments. This is a date, time, and place for a second hearing non-payment rent matter.
Ms. Austin White, your name? You got unmute.
Brittany Austin White.
Okay. What do we have here?
Your Honor, we had a chance to meet. We can agree to a consent judgment. I can put the terms on the record if you'd like.
Please.
Miss Austin White has agreed to pay $600 by Friday.
Well, you got to give me the breakdown first.
Okay. I'm sorry. The total amount they'd be doing on, which is inclusive of March's rent, I apologize, Your Honor, 771.08 plus 1 would total $2,906.08. It's been a minute for me. I apologize. I was going to put the terms of the settlement on the record.
Listen. I don't know why I'm a little irritable today. I am. I'm going to take the time to let you go back and figure that all out. All these cases, I need to know. Rent to retain, late fees and costs. If you got that information, I'll be glad to listen to it now.
I've got it. I did it a little sideways. I apologize. I was trying to break it down even further to keep it simpler, and I apologize.
All right. Give me your rent to retain. Do you have that ready to go?
Yeah. I got to the, if you give me a minute, I'll take the cost off. I thought I was doing it the simplest way.
You're assuring me that the late fees do not exceed $75.
I'm assuring you that, and I've waived the late fees and these payment arrangements to try and.
Fine. Give me the breakdown then on the, just tell me how much is owed plus the cost. Rent to retain with late fees is how much?
$2,906.08, which is total inclusive of court costs, filing fee, and statutory attorney fee. That's a total amount due annoying.
All right. And then the terms are of a consent judgment.
$600 by Friday the 27th. $600 by March 6th. $571.08 by March 13th. And March's rent with no late fee, $11.35 by March 27th.
You said by March 27th?
Yes, Your Honor.
You agree to all those terms, Ms. Austin White? And does he have your permission to sign your name to this proposed consent, Judge?
Yes, sir.
So the judgment amount will be for $2,906.08. It has to be paid at the following rate: $600 by February 27th, $600 by March 6th, $571.08 by March 13th, $11.35 by March the 27th. So long as you make those payments as agreed upon, you can stay in the property. You'll owe the plaintiff nothing insofar as the judgment is concerned. However, if you miss any one of those, he's going to submit an application for a writ, and I'm going to sign it, and you're going to be evicted. Do you understand that?
Yes.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal. Do you understand that, ma'am?
Yes.
All right. Any questions?
No questions.
Okay, so we're done with that one. You're all set.
Thank you.
Good luck. Then I've got Marion Manor versus Jasmine Parker, 2600341. If I'm missing anything, you got to tell me.
Absolutely, Your Honor. Your Honor, this is Andrew Smith, 64541, appearing on behalf of Marion Manor.
Jasmine Parker, your name.
Jasmine Parker.
All right. Did you two talk?
Yes.
We have, Your Honor. We've agreed to a consent.
Okay.
Your Honor, we came here today with a total amount due and owing of $2,155.48. There was $140 of that was a late fee, $70.04 filing, and $31.50 bailiff fee. We have agreed to a payment arrangement, which would include that amount plus March without any late fees towards March. I can put that on the record if you'd like.
Okay, go ahead.
Miss Parker has agreed to pay $1,355.48 by Friday, March 6th, and March rent of $1,095 without any late fees included by March 20th, Friday, March 20th.
All right. Do you agree to those terms, ma'am?
Yes.
You understand, since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. And you have 10 days to appeal. Do you understand that?
Yes. Yes.
Do you agree to all these terms?
Yes, sir.
Since you're unrepresented by a lawyer, again, you have 3 business days to come in and fill out a motion to set aside the judgment and 10 days to appeal. You understand all that?
Yes, sir.
All right. He's going to, does he have your permission to sign your name to this proposed consent judgment, ma'am?
Yes.
All right. You're all set. I wish you well. Thank you.
Thank you, Your Honor.
Hamptons versus Aaron Kennedy, 2600322.
Good morning, Your Honor. Andrew Smith, 64541, appearing on behalf of the Hamptons.
Good morning, Ms. Kennedy. Your name?
Hi, Aaron Kennedy.
All right. Any resolution?
Yes, Your Honor. We've had a chance to meet and enter a consent judgment.
Okay. Go ahead.
We came here today with a total due and owing of $3,072.40. That was made up of $140 in late fees, $70.04 in a filing fee, and $31.50 in a bailiff fee. We have agreed to a payment arrangement for Ms. Kennedy, which would include March's rent, which I can enter on the record if you like.
Sure.
Ms. Kennedy has agreed to pay $1,500 by tomorrow, February 24th, $500 by Friday, February 27th, $500 by Friday, March 6th, $572.40 by Friday, March 13th, and March's rent with $1,380 by Friday, March 27th, and that does not include a late fee.
Okay. And you agree to those terms, ma'am?
Yes, sir.
If you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment, and you have 10 days to appeal. Does he have your permission to sign your name, and do you understand everything I just said?
Yes, sir. He does, and yes, I do.
Okay. Any questions at all?
Not at all.
Okay, just stay with those payments and you'll be able to stay. Good luck, ma'am.
Thank you.
Hamptons versus Reuben Plummer Jr., 2600335.
Good morning, Your Honor. Andrew Smith, P64541, appearing on behalf of the Hamptons. I do not believe Mr. Plummer is checked in this morning.
We have not had him checked. We have not had him check in, Your Honor.
You can go ahead and take your default.
Thank you, Your Honor. Do you want the amounts or just?
Sure.
Your Honor, I'm asking the court to enter a default judgment of a total $2,776.54. That's inclusive of $140 in total of late fees, $70.04 for filing, and $31.50 for a bailiff fee.
Writ date will be the 5th. You can submit your judgment on that case. Thank you. Williamsburg versus Stephen Tao and Brittany Angle, 2600159. Your name, please, again?
Good morning, Your Honor. Andrew Smith.
All right, Mr. Tao and Ms. Angle, your name?
My full name, Your Honor, is Steve Tao.
Okay, good morning.
Your Honor, I'm Brittany Engel.
All right. Any resolution on this one?
Yes, Your Honor. We've had a chance to meet and we've agreed to a payment arrangement.
Okay.
Terms on the record.
Sure.
We came here today with a total amount due and owing of $1,381.43. That was inclusive of a $7 late fee, the filing fee, and bailiff fee. We've agreed to a payment arrangement, which would include that amount plus March's rent, which is $1,105. There's no late fee included. I can put the terms of their payment on the record if you like.
Sure.
They've agreed to pay the $1,381.43 by Friday, March 6th, and March's rent of $1,105 by Friday, March 20th.
All right. Is that true, Mr. Tao?
Yes, that is correct.
Ms. Angle?
Yes, Your Honor.
You have 3 business days since you're unrepresented by a lawyer to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal. Do you understand that, Mr. Tao and Ms. Angle?
Yes.
Yes, Your Honor.
Okay. So that's what I'll do. And does he have your permission to sign your name to that proposed consent judgment?
Yes.
Yes,
Ma'am? Ma'am, I
Yes,
didn't
Your
hear
Honor.
you. Okay, so you guys are all set. Make sure you make those payments as indicated and you'll be all set, okay? Thank you.
Good luck, guys. Thank you, Your Honor. That's all I got.
Okay, thanks a lot, Mr. Smith. Have a good day.
You too. Take care. Thank you.
Do I have JMZ Management versus Stacy Moore? JMZ Management versus Stacy Moore.
Good morning, Judge Joe Joseph. Tepe.
You got to start your video, please. Do I have
I'm working
Stacy
on it.
Moore? I have Stacy Moore here.
We have not had her check in, Your Honor.
You can go ahead and take a default, counsel. Go ahead.
Thank you, Judge. We would move the court for entry of a default judgment. This is a possession-only termination and tenancy case. So we would ask the court to enter a default judgment, again, possession-only with a writ date of March 5th.
Okay, I will grant that request. You submit your judgment and you should be all set, right? Thank you.
Thank you, Judge.
Thanks a lot. David Kasser. David Kasser, and then I'm taking the 2 arraignments and then I will be with you guys.
3 arraignments, Judge Holmes in custody.
Okay, David Kasser versus Alawasian Ejado, 2600685. Mr. Kasser, your name?
Good morning, Your Honor. I'm David Kasser.
Mr. Ejado, your name?
Good morning, Your Honor. My name is Ejado.
Okay, you got to keep your voice up really loud for me, okay?
All right, sir. Good morning, Your Honor. My name is Ejado.
Lot louder.
All right. Good morning, Your Honor. My name is Ejado Oluwaseun.
Okay, did you listen to and understand the rights, sir, on the video?
Oh, yes, sir.
Do you wish to speak to a lawyer or apply for funding?
I already have a conversation with them.
I can't hear you, sir. You got to go a lot louder, man.
Yeah, I already had a conversation with Mr. David Kasser.
Your Honor, this is a termination case.
All right. Okay. Did you 2 talk?
Yes, Your Honor.
Any resolution?
Yes, Your Honor. The gentleman is going to move out within 10 days.
All right. And so this is going to be a consent judgment?
I think so, Your Honor. There was a little language barrier, but I think so.
Mr. Ejado.
Yes, sir. Yes, sir. Yes, Your Honor.
Do you agree to a judgment in favor of Mr. Kasser and against you that says that you have to vacate by March the 5th?
Yes, sir. I agree, sir.
Does he have your permission to sign your name to a proposed consent judgment to that effect?
Yes, we already spoke earlier, and we agreed.
You gotta go louder.
we had the conversation earlier. So we have agreed that if I can come up with all the amount before the 6th.
This isn't for non-payment of rent. This
Yes.
is for, he's just asking that you vacate.
Yes, I agree.
Do you agree to vacate by March 5th, whether or not you can come up with money or not, don't come up with money?
Okay, sir. Yes, I agree.
Do you
Yes.
fully just stop a
Yes,
second.
yes, I agree. Yes, I agree.
Do you fully understand everything I'm telling you? That is that you have to leave by March the 5th, irrespective of whether you pay or not?
Yes, I understand, sir.
You agree to that?
Yes, sir.
Does he have your permission to sign your name to a proposed consent judgment reflecting that?
Yes, you can.
Since you're unrepresented by a lawyer, you got 3 business days to come in here and fill out a motion to set aside the judgment. You got 10 days to appeal. Do you understand that?
All right, sir.
Do you understand that?
Yes, I do.
All right. That's what we'll do. March the 5th, you can submit your judgment. I need it today, though, Mr. Casser, okay?
Thank you, Your Honor.
Thank you very much.
Thank you, everybody.
People against, which one's this? Flat Rock?
They're all fun.
They're all in Flat Rock?
We have them in custody, Judge.
Are they all in Flat Rock is what I want to know.
The answer is
Who do you have in front of you there, officer?
yes, Judge. Well, no.
I currently have Anthony William Rose here.
Gibraltar is Bill's. We also have one in Woodhaven.
Anthony, all right, let's just take one at a time here. Anthony William Rose, 25F244639. Mr. Rose, your name?
Anthony
Rose.
385, Judge.
You know this is Judge Hessens, right? Everybody knows that. It's fine.
I can take that over.
No. Your name, sir?
Anthony Rose.
All right. Well, where's he been? He doesn't like to show up.
First of all, good morning. Your Honor, I have wrote something on the Register of Actions housekeeping. I added the apartment number and I changed Monroe to Lincoln Park LP to properly reflect the address that was not listed correctly on the register.
You know how many times you failed to show up?
Yes, Judge, today's the date and time set for an arraignment for Mr. Rose on files 385 and 639. Mr. Rose, bear with me here.
He already pled, it looks like, and it looks like he's here for he's going to be sentenced.
Correct. Yes.
So I should just set about a $10,000 cash bond and set this for next October since he doesn't like to show up, right?
I'm so sorry. I'm
No, you're
sorry.
not. Don't tell me you're sorry. You missed about 4 times here. Maybe that's what I'll do. I'll set a big high cash bond. And then you can sit there for 8 months and think about why you act like a fugitive and continue to act like this. 5,000.
Thank you, Judge.
10%. Well, I don't know. Was he posted that before?
No, I didn't see that. I saw where you put the that on with the 10%.
Boy, you got to grow up. How old are you? 6?
36, Your Honor.
Oh, okay. Well, you're about acting 30 years younger than you really are.
So
I'm just been busy taking care of my mom. Like my mom's really not doing well, so I've been taking care of her.
Where was he picked up, officer?
I believe it was in Lincoln Park.
Whereabouts in Lincoln Park?
That I'm not too sure of. I just know we were contacted by Lincoln Park.
I was picked up by my mom's house.
Why were they where were the police there?
Me and my brother.
Well, you got in a fight or something?
No, me and him were getting in an argument, and he's like that.
All right. Can Judge Hudson take this today? You guys, can you find out if she can take this or wants to take this today?
I'll check on that, Judge.
And Your Honor, I can take care of that for Mr. Rose once we get Mr. Caballero resolved.
Mr. Caballero's another one here, huh? He's going to be one of these guys on the list again. I mean, the guy never shows up.
I'll take care of Mr. Rose's sentencing today after that.
I just don't know if she can do it or not, so I'm trying to figure out. Jennifer, or Linda, can you find out? You know what? I'm gonna let them deal with this. I don't know what to tell you.
Jen is talking to Lisa right now, Your Honor.
Yeah, I don't know what
About
to
it.
do on this. Oh, wait, they've just got March 12th.
Yes.
We don't want the guy sitting in custody until March 12th, do we? I mean, even though he's been very disrespectful, Mr. Rose, you know, I still have a function and a job, and I'm not going to be vindictive, even just because you act like a little child. And that's the truth. So, how many warrants you got? Tell them I don't want to go to March 12th, will you, Jennifer or Linda? I tell them I've got this
Sure,
guy
Honor.
here. If they want to just call Flat Rock and tell them what the sentence date is, that's fine. But I got to move on here. I've got people here that have been waiting.
There may be a PSI report that may need to be done.
I don't know what she ordered. I can't tell. It looks like screening and assessment. I don't know if he underwent the screening and assessment. Did you get screened and assessed by probation?
I went to probation and filled out all the paperwork, yeah.
Check with probation and see if there's a report ready. Judge, I can take care of that. I can go down to Judge Hudson. I apologize.
No, it's okay. I didn't know. I was just pointing out that it was hers. And I didn't know that all these guys were in custody of Flat Rock. It's fine.
Okay.
I just need an answer from them, Linda. Would they please give me an answer?
What would you like, Judge, as far as
I
you
don't
to see
want
if
the
Judge
guy
Hudson
to
can
have
see
to
him?
wait in jail till March 12th. That was written on the front here. I don't want him
Okay.
to have to do that.
That's the next Flat Rock date, is what I was told.
We don't
So,
need a Flat Rock date. He didn't show up for sentencing.
Okay, I will
And
get
he
back with you in
said
just one moment,
today.
please, Judge.
Well, I'm just passing this. You got to figure it out.
Okay, so I'll go talk to probation, see if we got the report.
Thanks.
And Judge, we have the others as well. At the report.
I get it. So that's what we'll do. You'll hear from them and they'll tell you, I guess. I don't know what else to say. Hamza? The dog, 25W839-293.
Attorney Mark Bolden, 7, the reigning attorney. Sir, as you approach the podium, come on up, sir. It's okay. And just.
Are we all set, Your Honor?
Yeah, keep your hands on your.
On just that one, I think we got other ones with these guys, don't we?
On Anthony Rhodes?
No, he's the only one in custody now. He was just asking if he was also.
Is Joseph Bills in the courtroom?
He is.
Yes. Yes, sir.
All right. Do we have, you're all set on that one. My apologies. You're going to hear from them as to when they're setting the sentence date.
Okay, thank you, Your Honor.
Does he stand mute? Wait, formal reading on this?
Your full legal name, please.
My name is Hamza Al Khalafan.
Yes, Judge, he does.
Where's he been?
He's got something out in Lincoln Park as well. I do believe he walked in. He walked in on this, correct? You weren't picked up.
Yeah, but he walked in 8 months late.
I was.
Where you been? Where have you been? Why didn't you show up on this case 8 months ago?
You understand what he's asking?
I just didn't know. It didn't come to my house. I didn't know.
They handed you the ticket, right?
They did.
Yeah.
Did you call the court and say?
May I, Judge? He's not familiar with the judicial system. He's a permanent resident. He has.
Do you have $100 with you?
I'm sorry?
You have $100 with
Yes.
you. $100 bond, 1,010%. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. We're going to set this court date,
March 4th?
March 4th at 10:15. Okay?
Yes, Judge. Thank you very much. So you'll come back on March 4th, go up to the counter, they'll get you a piece of paper, and I'll have your date. Make sure you show up. Okay, post them. Okay.
Okay? Go down the hall, get your notice, but you're going to have to post $100. Don't be late again.
Judge, you all set? You are all set. Thanks, Dan.
Do we have Gibraltar out there or? See, this one says police
It's
department.
not
What?
custody.
Okay, Anthony William Rose.
Please help.
Yeah, Judge, it's gonna be Joseph Bills. Rose was the in custody.
I know, but we got to get Flat Rock back on. There's a second file here.
Yeah, and I put that on the record. I mentioned that, about three.
I didn't know. I didn't make anything. Joseph, we got to get Flat Rock back on. Could somebody call Flat Rock with him? Joseph Wayne Bills, 26G 702074.
Your Honor, for the record, arraignment attorney Mike Baldwin, Key 65417 on behalf of Mr. Bills.
Do I have a police officer from Gibraltar on Zoom?
Joseph Wayne Bills.
All right.
Purposes of arraignment today, Judge, my client stands mute, waits formal reading of the general information and complaint. I give you just some very brief background.
Just give me 1 second here. I need to know if is Gibraltar out there? So he's charged with.
Well, July 3rd, enhanced notice, driving while license suspended second, and high BAC 0.17 notification. So this is a felony, Judge.
All right, I get it. I'm going to advise you of your rights. You have the right to remain silent. You don't have to say anything. If you do say something in or out of court, whether orally or in writing, it can be used against you. You have the right to be represented by a lawyer at all subsequent court proceedings. You have the right to a probable cause conference and the preliminary exam. At the probable cause conference, your lawyer will discuss this case with the prosecutor. At the preliminary examination, people will have to show that the crime was committed and that you were the one who probably committed the crime. If they prove that, they'll be bound over for further proceedings to the circuit court. If they fail to prove that, the case would be dismissed and you would be discharged. Do you understand that?
Yes, Your Honor.
So your probable cause conference will be March 3rd at 9:15. Preliminary exam will be March the 10th at 11:30. Do you happen to know, did anybody call Gibraltar on this? Do I have anybody from Gibraltar out here on this, on Joseph Bills?
I don't think so, Your Honor.
We'll call Gibraltar now.
Yeah, that's okay. Well, it wasn't your responsibility. I'm not suggesting that, you guys. Let's just address the bond here. Does anybody?
Gibraltar's on.
They're here?
Yep.
I just want to ask him a couple of questions. Officer, I'm so sorry about the other, this Mr. Rose again. I got case number. And I see now what they're telling me makes more sense too. Because he's put himself in a bad position now. All right. Nothing.
Yeah.
All right, let's talk about bond. Gibraltar,
They're in there.
come on in, detective. Talk to me. Tell me your name, Detective Robinson, and tell me a little bit about the case. I want to know what the blood or breath result was. Thank you.
Yes, sir. I'm bringing that up right now. I just got the call to come in here. Sergeant Gary Robinson, Gibraltar Police Department.
Okay.
I'm going to need just a minute. Sorry about that.
That's all right. Take your time. I'm going to let him address bond while you're bringing up the information. I've already told them that the PCC is on March the 3rd at 9:15 and March 10th at 11:30, the preliminary exam.
And there was a police report, I believe I saw in here.
Yeah, but I don't, that's not appropriate for me to look.
Yes, I understand that, Judge. Thank you. Judge, my client is a full-time employee at a gas station. He takes care of his grandbaby when the parents are unable to do so. He's got a little bit of history of not showing up for court, and I could just bring that out on the table straight up front. But he's here with us today, and he's here to address the matters.
Does he, how much does he make in his employment?
I make probably $400 a week, Your Honor. Give or take, work roughly between 30 and 40 hours a week at my job. And
How old are you?
I'm 52.
All right, can you tell me, Detective Robinson?
It's open up right now, sir.
Okay.
So I believe his was a crash West Jefferson, Middle Gibraltar Road. He hit a guardrail. The officer showed up. He's intoxicated. Let me look at his blood. His blood was a 233.
5,010% is his bond. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. You're to attend AANA at least 3 times per week. Now, can you post the 500?
I can post the 500.
All right.
I have to get.
Hang on. Let me finish. I can do one of two things. I can either order you not to be released until fitted with a SoberLink device, or I don't know how you got here today because you have a revoked license. Somebody would have to drive you out to Macomb to get a SoberLink device. You're going to have to pay for that. If you're telling me, Judge, I've got the money, I can pay the 500 bond now, and I've got the money to go out to Macomb and somebody can drive me right after this hearing, then I'm going to let you do it on your own. If you don't have the 500 right now, or if you don't have somebody to give you a ride, I'm going to have to order you to go to the Wayne County Jail and that you not be released until fitted with a SoberLink. The problem if I do that is you're going to be sitting in there for 3, 4, 5 days. You got it?
Yes, sir.
You have the 500 with you?
Not, I mean, no, sir. I could, if I'm able to contact somebody, I can get it.
He can use the court phone system, correct, Judge, to make some calls?
Yeah, we'll let them make calls, but they got to rush up here. We're not holding you in this facility for more than a half an hour or so.
Yes, I can't say.
Are you 100% sure?
98%. My wife is just waiting for me to call, but she's the one that's taking care of my grandbaby today due to the fact that I'm not there. You're taking care of it.
Call, go out in the hallway and call. Do not leave this building though. You understand me, right?
Yes.
I'm going to extend that courtesy to you. I'm going on to another case and then you're coming back. But you are also defendant to obtain SoberLink device by the end of the day. So I'm going to let you, that's a condition of your bond. And if you don't follow this, you're going to have a big problem. You still live on Cornell?
Yes, sir.
You go out in the hallway and you call your wife and you come right back in here, okay?
Yes, sir.
Thank you. Now I see what the problem was on Mr. And you're all set, Detective.
Thank you, sir.
Anthony William Rose, 267-245-385. Now I know what the problem was. Your appearance again?
Thank you. Arraignment attorney Mike Holden, P6541.
All right, counsel. Does he stand mute on this other disorderly public intox that I just discovered that I have?
385, yes, Judge.
All right. Well, you got a problem now, Mr. Rose, since I know your name again?
Anthony Rose.
Since I know that you don't show up in court, $2,500, 10% on this case too. And you cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. I want you to give him an AA verification sheet, officer. If you don't have one, we'll give you one. No alcohol, no marijuana, no illegal drugs. You're to attend AANA at least twice a week. You have to go in person. No alcohol. You cannot have any contact with prosecution witnesses except through your lawyer. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. Do you understand all that?
Yes, Your Honor.
Judge, can he also, I believe that the police department will have the court appointment.
Yeah, give him the court-appointed petition to fill out too. And the problem is now you got a March 12th date. You keep playing games with the system. March 12th will be your pretrial. That's the earliest date I can give you.
So that's resolved.
But he didn't show up on this one either, March 12th at 10. Stop acting like a fugitive, okay? Will you please?
Yes, Your Honor.
Where do you work at?
I work in my mom's.
Yeah, I got this.
Where do you work at?
I work in my mom's co-op building in Lincoln Park. I do janitorial.
Okay,
And he's also taking care of his mother at this facility.
all right. Good luck. Thank you.
Thank you, Judge.
Folks, my sincere apology to you, okay? I'm gonna call this case now, Anthony Butler versus Paul Robertson and Shauna Robertson. Now, I don't know if you guys are gonna, if you have something that is going to tell me that this is resolved. I was told it was when I asked your name. I'm sorry, say that again? Oh, yeah. And your name?
Anthony Butler.
Your name? Your name?
Paul Roberts.
You guys came up with an agreement?
Yes, sir.
Who wants to tell me what it is?
Okay, so when we met, they are still planning to move out by March 31st. This Friday, the 27th, they will have $2,000
So you're agreeing to a money judgment for how much?
for $9,500.
For how much?
$9,500.
So you're agreeing to a money judgment, the amount of 9,500, right, total?
Correct.
Let me just put all this down. All right, go ahead then.
Yep, they're to be out by March 31st. First payment they agreed on was this Friday, the 27th of.
Slow down 1 second. Let me just, I'm trying, I want to write this all on the judgment. So this is converting to a termination of tenancy that you're going to vacate by March 31, right, sir?
Yes, sir.
Right, man? Right, sir? That's the agreement?
Yeah.
Okay. And how much what are they going to fine or pay at what point?
They said this Friday they will pay $2,000. 27.
Hang on. $2,000 by February 27th, right?
Correct.
Okay.
And then the next payment would be April 1st of $1,500.
Okay.
And then another $1,500 May 1st
Okay. Is it $1,500?
until it's paid off.
1,500 more by April 1st and the first of every month thereafter until paid in full, right?
Correct.
All right. So here's what I want you guys to do. I'm going to cover all this with you. This would be a consent. I want you guys to sit down and I want you to read what I have just entered here. And you can, I'm going to have you sign plaintiff and defendant. You're going to have to squeeze it in here. There's one signature line for plaintiff and one for defendant. So you're going to have to write your name up on the top. I'll write down here. I'll show you. And you're going to date it. And you two sign it. And then we'll go over everything in here. Okay? If you agree to it. Just make sure that you understand it and agree to it. The 23rd today. John, would you call in and see if Mr. Bills is out in the hallway? Just call him 257, you know. You can just.
I'll speak up there.
Your Honor.
It's all signed by everybody?
Yes.
Okay, you can hand it right to her. All right, so I want to cover the terms again. You did sign and read and understand this document, Mr. Butler?
Yes.
And Mr. Robertson, did you?
Yes, Your Honor.
And Ms. Robertson, did you? So you understand, according to its terms, you have to vacate by March the 31. And in addition, and if you don't, you're going to be evicted. You understand that, right, Mr. Robertson?
Yes.
Ms. Robertson? And in addition, you're agreeing to a money judgment in the amount of $9,500 with no costs assessed on that, right?
Yes.
Right, ma'am? And you understand you have to pay that at the rate of $2,000 by this Friday, February 27th, and then $1,500 more by April 1 and the first of every month thereafter until paid in full. You understand that, Mr. Robertson?
Yes, sir.
Ms. Robertson? And again, you agree to those terms?
Yes.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal. Do you understand that, Mr. Robertson?
Yes.
Ms. Robertson? And you agree to all this, right, Mr. Butler? And that's your signature, right? And you both signed this on this document, correct? Mr. Robertson, you signed it? Ms. Robertson? And you have until March the 5th to appeal.
He's on the phone, still trying to work it out.
All right. Thank you very much. You can all go down the hall and get a copy of the judgment for your records. Best of luck, folks. Thank you.
very much, Your Honor.
Thank you. So this has to go down, John. Where's that Robertson file?
That gentleman who got his vote, that means anything to anyone, he's coming back.
Oh, he's coming back, yeah. I'm gonna need Mr. Baldwin and Mr. Bills in here. Tell them in 2 minutes.
The discovery, there's quite a few videos. So and be ready soon. We have not reached a plea agreement at this time.
Here.
A very nice handwritten application for writ habeas corpus from the defendant to the 252nd District Court where he is not in. So we got somebody who's working with you here as your partner. Looks like.
Yeah, sometimes that happens, Judge.
So when can we be ready on this? Oh, what is it? The third enhanced to a second from another robbery conviction. Y'all ready, essentially?
I mean, I'm still reviewing discovery, but I can do probably the reset.
Okay, reset.
This is not on the trial document.
Not yet. No, I'm about to put it on the top.
Yes, sir.
Yeah. Okay.
So thanks, Judge.
Okay. Stanley Etheridge. We're going to need Stanley Etheridge.
Yes, sir.
What about Brandon Foxall?
That's also the plea we need him as well.
Okay, both of them in the queues. Thank you. Emily Jones.
That is also a plea.
Corey Morgan. Well, you just got a bunch here.
Corey Morgan is a sentencing ready.
Okay. Well, you're about to be the star of the show. Kimberly Thompson.
That's a dismissal status file motion.
TDB. Ricky Washington.
That is shown in trial line.
1, 2. Okay. Mia Whittley.
That's just leaving. So everybody's at their inch and off balance. Yes.
Okay. We'll get somebody in here for that, test on that guy. Okay, great. Please. On 10 over 10. What are we doing on James Franklin? What is this hearing all about? So it says a hearing.
He's always mad that he's not first in line for trial because he wants to hurry up and have a trial so he can get a really long sentence, even though his case is younger than a lot of other people. I just
we've been unable to figure out how to do more than one at a time,
and me in particular be in more than one place.
Yeah, I'll bring him out. So talk to him. Okay, he's got 2 cases, correct? Yeah.
I just told him it was that
Reagan
just wants to hurry up.
Manaldi, Reagan, you know,
very good.
You are Mr. Etheridge, right in front of this lady. She's going to swear you in, and then we'll come over and take your case for disposition.
You swear at war firm? You swear at war firm? You live yourself, God? Okay, you can do it right now. Looks like right there on the wall. Yeah, might need it much sharper than that. But here, put it right here. One more time. That happens.
This was happening in Fredericksburg, Texas.
She said,
They're building a gigantic hotel.
okay, you go stand.
New York. Gonna see if Manhattan comes into the German hill country. This is the fancy New York hotel.
I use her, but I want her sitting.
I mean, all right. Interesting. That's those 2 cultures will evolve. And I need a phone. It would be. Understand. Yeah, yes, okay. We got them rolling here. 25 CR 1457 is called the State of Texas versus Stanley Curtis Etheridge. That's you, sir. And you were here with Mr. Dusler. You were attorney and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in summary? Yes. In summary, Mr. Etheridge, this indictment alleges that on or about September 19th, 2025, in Jefferson County, Texas, you committed the 3rd-degree felony of what's called continuous violence against the family. It states you intentionally, knowingly, and recklessly caused bodily injury to another person with whom you had a dating relationship and assaulted that person. Do you understand what you're charged with here, sir?
Yes, sir.
It's a 3rd-degree felony if convicted, which means you face no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes.
An agreement has been reached. He would be pleading guilty, sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for 10 years, fined $1,000, and there would be other terms and conditions of probation, which are normal and customary for this type of offense. Do you understand what is happening here?
Your Honor, the only,
we got an issue here on the signing of this agreed punishment recommendation.
Yeah,
Redo that.
He wrote on my line, Judge, so I kind of made a line there.
Okay, we got to start over.
tell us it's jail, aren't they, three?
Be careful on listening. That is the most interesting stylus that's ever been manufactured. it takes more than just coordination. It's almost like you have to perform a magical act.
See, that's what lets me ask you the coordination part.
You gotta hit two things at the same time that are in different spots for it to erase. Which is, I don't know. You would think.
And Judge,
It'd be a better way to make a.
the agreement is for 10 years and then be placed on supervision. He's going to ask for less than 10 years.
Hey, before I sign this, can I ask a question? Can I ask a question?
Can he ask a question?
Oh, yeah. Then try math. I'm real good at that.
Okay, it's $1,000, but the 10-year probation, is that $1,000?
I don't even know what you're talking about.
The fine can be $1,000 over the term of probation, not all of the time.
Okay.
Yeah, you do a little bit at a time, like you're paying a car note, but it's no interest. There's no interest charged. But at the end, you don't get a new car.
Okay. But do I have a chance to get out?
Yeah, but you're going to get out. You don't have to pay your fine when you get out.
Okay.
It's going to be over the term of probation, a little bit at a time. And if you do well on probation, your probation can be shortened to 1/3 to just 3 years, a little over 3 years. And that's what I do every day is shorten probation. 93% of the people are successful on probation on our watch. If I follow this agreement, sir, you have no right of appeal. Do you understand that?
Yes, sir.
How do you plead to this, guilty or not guilty? How do you plead guilty or not? Are you pleading guilty voluntarily? That is on your own free will.
Yes, sir.
And because you are guilty.
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it?
Yes.
Discuss it with your attorney. Or the contents all true and correct here?
Yes.
State's Exhibit 1 is tendered into evidence, and without objection, it's admitted. Among other things, the state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. You are guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true, so help you God.
Yes.
State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is here again?
Yes, sir.
All right. Do you still have any relationship here with the victim in this case?
Yes.
You do?
Yes.
Uh-huh. What are we doing about that?
Needs to be a no contact, Judge.
We are separated. We live in 2 different residences. And we say, the relationship was a 9-year relationship, and still brings us stuff like that. The situation was it wasn't a violent thing, it was a violent act.
That's not what you just pleaded guilty to.
But I pleaded
this. Don't say you pleaded guilty just to get it done.
Yeah.
You either pleaded guilty, you were under oath, you either committed a crime of lying, perjury, because you said all of this was true and correct. All right. This states you pulled her hair, threw her to the ground, intentionally and knowingly caused bodily injury.
Yes.
You call that a love relationship?
Whatever.
That doesn't act like it. No.
But you all still put it together.
We're gonna have to
Well, don't say that you didn't do anything wrong here and if you treat somebody you care for, you had a relationship, an intimate relationship with, what would you do to somebody you didn't care for when you got upset? I mean, that's just, you got to control your temper, I guess. But this isn't the way that you show love toward another person, right?
Yes, sir.
Okay, we'll fix that.
Yes, sir.
All right, if nothing further, I'm going to find you are mentally competent into this guilty plea. It is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of this crime and any lesser included offenses. I find you were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer.
Yes, sir.
And based upon State's Exhibit 1 and your representations to the court, your entry of plea of guilty, it's voluntarily, knowingly, and made upon discussions with your attorney, I hereby find you guilty beyond a reasonable doubt of this third-degree felony of continuance violence against the family. And I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice prison for a term of 10 years. That term of confinement is suspended. You are placed on regular probation for 10 years. You must pay a fine of $1,000. Was there any restitution here? No, this lady?
No, sir.
There will be terms and conditions of probation, which are normal and customary for this type of offense. You must complete the Batterer's Intervention Protection Program. That helps you maintain your composure when there are times of stress. And you will have no contact with this victim unless otherwise ordered by the court. Make sure you follow these terms and conditions of probation. If you fail, your probation could be revoked and you could be sentenced up to 10 years in prison. So make the most of this second opportunity, okay?
Yes, sir.
Anything else? No. Thank you. That is all.
No, you don't want to be hurt.
Here's that. Brandon Hoffpowell. Honey Brandon. Thank you. And we all heard that one. State jail. What is a state jail punished as a second-degree felony? It's got 2 and 3 or yes. Yes. Different punished. Punished as a third-degree felony. It's a third-degree. 2 state jail permits. No, but there's 2 trips. But those 2 state are 2 state jails mentioned third-degree possession.
Name one, right there. Okay.
Even in sequence? Yes. Yes. You are Brandon Edward Hoffpauer. And here with Mr. Dusler, your attorney and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, Mr. Hoffpauer, this indictment, stand by. Pains, God bless him. This indictment alleges that on or about September 25th, 2025 in Jefferson County, Texas, you committed the state jail felony of terroristic threat against a peace officer. Do you understand what you're charged with here?
Yes, sir.
Now, paragraphs 2 and 3 go on to allege that you have prior convictions of state jail felonies, one in 2014 out of the 252nd District Court of Jefferson County next door for illegal possession of a controlled substance.
Yes, sir.
And paragraph 3 goes on to allege that you were convicted in 2021 in the 128th District Court of Orange County, Texas for illegal possession of a controlled substance. Paragraphs 1, 2, and 3 constitute a state jail felony but it is punished because of the prior convictions as though it were a third degree felony. Do you understand how that works, sir?
Yes, sir.
Which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached where you would be pleading guilty to paragraphs 1, 2, and 3, sentenced to 3 years in prison. And you will, of course, be given credit for all time you have served in accordance with this matter. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge of a state jail felony terroristic threat against a peace officer? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And paragraphs 2 and 3. That and looks just like a 3. It looks like 1, 2, 3, 3. I'm going to fix this in.
It's fine.
If let me show you what's marked as State's Exhibit 1. Did you sign that document?
Yeah.
Understand it? Discuss it with your attorney, or the contents all true and correct?
Yes.
State's Exhibit 1 is tendered into evidence without objection.
No objection.
All right. And how do you plead to this paragraph 1, state jail felony? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And paragraphs 2 and 3, those prior convictions we discussed of state jail felonies, are those true and correct as they are alleged?
Yes, sir.
And are you pleading true and correct to those voluntarily and because they are true as they are alleged?
Yes, sir.
This constitutes a state jail felony, but it is punished as though it were a third degree felony. And that's how you get the more than 2 years confinement, 3 years as agreed upon. In State's Exhibit 1, among other things, this states you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read the indictment. It is you were guilty of the crimes charged and any lesser included offenses. You're giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, this state, so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is made.
Yes, sir.
Nothing further. I will follow this agreement and find you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt. Paragraphs 1, 2, and 3, constituting a state jail felony, punished, though, as a third degree felony because of the prior convictions. I'm following this agreement. You were hereby sentenced to confinement in the state jail for a term of 3 years. Do you understand?
Yes.
What has happened today, sir?
Yes, sir.
I think it'll be confined in the institutional division of the Texas Department of Criminal Justice, actually, not the state jail, because of the enhancement. You'll be given credit for all time we have served. Anything else to add, sir? Okay, good luck. Thank you. That is all. Yeah, it was balanced. Yeah. Emily Jones, but nothing on the queue.
No, this is a motion to revoke. There is not, not this time.
Hey, on this one, Patel. Mr. Patel. Where'd he go? That's yours, Ryan?
Yes, Judge.
Sager?
Yes, I'm here. Yes.
You're not Sager. He is. There he is. Come on.
Yes, sir.
Right.
No, that's not the way it's accident involving bodily injury. So what do we do? Take serious out and put bodily injury?
Well, we take serious, misspelling is serious and put accident involving injury.
The objection?
No.
It was serious bodily injury, it would have been a second degree felony. That's
Yes,
higher. This is a third degree felony.
Yes, Judge.
Is all of that true? That you were placed on 10 years deferred or unadjudicated probation for accident involving bodily injury?
Yes, sir.
And essentially, the essence is when accident occurs, bodily injury can occur, or worse, death. And the key, though, is when there is an accident involving bodily injury, you have a duty to provide reasonable assistance, stay, deal with any injured party, and include making arrangements for transporting or getting help as needed for medical treatment. And apparently you must have left the scene. This person did not pass, hopefully.
No, sir.
And that's what you always have to worry about. Is somebody came along and must have helped them, but you have the obligation under the law to stop and stay, not run off. So it's a third degree felony that you've been placed on probation for. Is all of that true and correct?
Yes.
Council 1 and 2.
Allegation 1 provides that you provided urine samples on or about August 28th, September 4th, September 9th, September 16th, September 23rd, and September 30th, 2025, all showing the scientific analysis of the presence of tetrahydrocannabinol or marijuana, which is a violation of condition 10 of your deferred order, which is do not use or possess any drug unless it's prescribed. Is that allegation true?
Yes, sir.
Yeah, I know the defense suggested 1 and 2, but we would like to be on counts 3 and 7.
Three states that you were unsuccessfully discharged from the Residential Substance Abuse Treatment Center on or about October 14th, 2025, which was in violation of condition 12 of your deferred or unadjudicated probation order that the court placed you on. Is that true and correct?
Yes.
And that's it. 12 states attend rehabilitation, treatment, residential programs, and counseling as directed, and pay for said treatment as directed and provide verification of such. Really, from probation, we really ought to change that one. As I'm looking on its wording, it ought to be attend and successfully complete. That we don't have that in there, but she didn't attend. So, but it says attend rehabilitation, treatment, residential programs and counseling as directed and pay for and provide verification of such. It should include attend and successfully complete those two words. That's 12. We're tinkering there as we go along. Okay. Is that allegation number 3 true? That you unsuccessfully were discharged from the residential abuse treatment center in October of 25?
Yes.
And 4 goes on to allege a bunch of series of you failed to abstain from intoxicating substances. You provided your examples.
You addressed that in count 1, Judge.
But these are these the same dates?
Yes, sir. The state's
Okay.
interested in sets, Judge.
That was kind of odd. That's just well, and I see the whiteout.
They're different conditions, Judge.
Count 1 is providing a sample showing the presence of substances.
It was a different
use of the
It was different, yeah. Well, not double jeopardy or. There, okay, here it is. Okay, then the next one.
My preference is 7, Judge.
And then finally, 7, you failed to enter and successfully complete the Jefferson County Drug Intervention Program, which was in violation of a special amendment to your probation. Is that true?
Yes, sir.
Okay, so are you pleading then true 1, 3, and 7 out of this motion to revoke unadjudicated probation voluntarily and because those allegations of violations are true and correct as they are alleged? Do you understand that a violation of 1 or more of the terms of probation, that is enough to grant a motion to revoke probation? Your probation can be revoked. You can be now found guilty and sentenced up. This is a 3rd-degree felony to no less than 2, no more than 10 years confinement in prison. Knowing the importance of all of this, do you insist on pleading true to these allegations 1, 3, and 7 from this motion to revoke probation?
Yes.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true in this matter. Let me see where we head here. I don't see an agreement.
We have not submitted.
Okay.
We have not submitted a joint agreement.
All right, this unagreed.
Yes.
Okay, go ahead. They may go first and last. What do you want to do?
Judge, the artist said, this lady is pregnant and that'll prevent us from being able to send her to safety. That's what we had initially wanted. And well, preference is to reset this matter for an updated PSI to give the probation officer an opportunity to explore some options.
When are you expected to deliver?
July.
That's problematic because as I understand, the wait period is not that long, so we can't order it at this stage. So I've asked the probation officer to come up with some stopgap measures in between.
When were you arrested? I'm thinking along here. When was you arrested and put in custody?
December 18th.
Okay. This motion was filed on December 3rd, right? Okay. So.
And I'll be honest, Judge, part of the reason why I had her plead to counts 3 and 7 is to show Your Honor efforts that have already been made to try to curb this activity before we got to you at this stage. And it's pretty apparent that she's struggling, to use your term. She's free falling, and we've got to do something.
We're looking at a period from August through September where you were consistent in showing positive urine screens, one after another, after another, after another, through at least through September 30th. And then which can't be good for the pregnancy because you became pregnant the next month, if my math is right. Because I've got 2 children. You have responsibilities. Do you have any children right now?
Yeah.
How old are they?
7-year-old and a 4-year-old.
And you're using drugs? No, you were using drugs when you had those children.
Yes, sir. They were in custody of my grandparents.
Were they your children?
Yes, sir.
Okay. I mean, don't you have a responsibility, just as the mother of the child, to be a role model?
Yes.
And to set a good example? You weren't doing that, were you?
Yes.
Where were you getting your drugs from?
The store.
At the store?
Yes, sir.
You're getting your marijuana at the store?
The
Who's selling that at the store?
The dispensary behind Target.
Okay. They open for business 24 hours a day, are they?
I didn't smoke that much, sir.
I'm sorry?
I didn't undertake drugs that much.
You tested positive over and over and over and over again.
It has stayed in my system.
Oh, is that your medical analysis?
No. I had
So you start testing positive August 28th. And then what is the last time we did it? September 30th. When we finally decided that enough was enough. And your then a motion to revoke probation was filed. You know, if you were free falling, and it's a good thing we got you in jail. Generally, they don't provide drugs in the jail. They do a good job of trying to stop that. That's what you needed, if not for you, at least for the well-being of the child and your other children that you have that you weren't role modeling for. All right, go ahead.
Just the way the probation officers described her removal from both of those programs, she's not only been self-destructive to herself, but a lot of others as well. If she's going to remain on probation, my goal was to have her go to safety, but you understand the problems there. I just don't think she's going to do well unless it's an incredibly structured environment. The other option I don't like for her either, again, because of the pregnancy, and that's, I offered 5 years as far as that's concerned, but ultimately at some point in time, she's
You can
got to
get
be
10
held.
years, understand that. You can be sentenced to 10 years in prison.
Yes, sir.
So I don't know, Judge. I just really haven't, this all came up this morning as far as me learning about her situation. So we haven't had a chance to explore other options. That's why I'd like to give the probation department an opportunity to see if there is another option before I have to stand here and ask for pen time.
Okay. What's the defense? There's no question that she needs assistance and she wants it. It looks like an awful lot of positive testing.
Well, it is.
It is, but it's over a period of 1 month. And it's not unusual for marijuana to stay in your system for 6 to 8 weeks. And I think, if I'm not mistaken, that since that time, she's still been reporting and she did not test positive after that date. So I think once she realized she was pregnant, she's trying to clean up her act. She does need help. We want her to get help. She's not eligible for safe fee right now because of the pregnancy. But I know she had problems on the other programs, but at least for right now, I would say let's try to put her back in one of these programs and see how it works. And if it doesn't, well, then safe fee would be an alternative after that. Whichever one. I think she's also been attending Narcotics Anonymous as well. So and she attended college as well. So if we could put her in one of those programs again and give her a chance, and maybe she can be successful this time. If not, we can always revert to safety.
So if you look at the administrative hearing, Judge, that was conducted on November 5th, the department realized actually ordered.
Let me see.
Safety and That's when we discovered she
Can I
was
be
pregnant.
probable cause affidavit of underlying offense
So your
here?
underlying offense, I don't have that, but I do have the PSI.
Here, Lacy.
That's always going to be fast. We should make that close. Drug tax is always going to be part of this, or the, so make something that should be used. I don't hear it.
If that's not sufficient, Judge, I can get your copy of the PC.
You know what?
Yes, sir.
That name here, let me see that again. Yes, thank you. That's a victim here.
Do you have the PC or do you need it?
Yeah,
You do?
yeah, it was. It starts off though with the victim who had a strong odor of alcohol. I mean, everybody was drinking here. The victim and the person and this lady who hit him. Everybody's driving and operating vehicles and are intoxicated in this one, the victim and the other, and the defendant. She admitted hitting somebody on a motorcycle while she was too scared to get out of the car and check. And you even said to the police you thought the victim was dead, that you would kill the victim. But he lived. Well, if this isn't poster for don't get intoxicated, everybody involved, the victim on a motorcycle and you in a vehicle, we're both intoxicated. Different people.
The administration saw the child. First last year was added 10 years. Beyond was 25 life.
Back, the victim was so out of it, he attempted to leave the hospital nude.
Yeah.
Which would have gotten some attention, I guess.
Victims years of age to
All right, but otherwise, have you ever been in trouble with drugs before, ma'am? Okay. You just lied to me, didn't you? Didn't you? You just lied to me because I know what your criminal history is. The first thing out of your mouth is a lie to me. That's what you're going to be doing. He's asking for probation You're not going to get it when you lie to the court. So tell me about your drug history, because I've got it here.
When I was
Don't even lie. Don't ever do that. You're under oath anyway.
when I was 17, I had a
You're old enough at 17 to be treated as an adult. You understand that?
Yes, sir. I had a possession, but
Yeah. Hardin County.
yes, sir. But it was deferred adjudicated.
Yeah, that's still a crime. You were charged with a crime and put on probation.
I thought if it was deferred, you weren't charged with it.
You're charged. You can't prosecute someone if they're not charged.
Okay.
You weren't found guilty. But you were charged with a crime and placed on deferred or unadjudicated probation. First opportunity you had, you would tell me a falsehood. That's no way to deal with your responsibilities, man. Yeah, you were put on 6 months deferred or unadjudicated probation and fined $200. You were charged.
Okay.
Don't act like you weren't, because that's not the first time you were in trouble. You have a rich juvenile history of theft, assault causing bodily injury, theft. Then you become an adult, treated as an adult, right off the bat, possession of marijuana. Now, here we go, accident involving injury. Thank you, Judge. And we put you on deferred or unadjudicated probation, and now we've got these problems back on drugs. And the thing is, you knew you had a problem and you didn't deal with it responsibly.
That's why I became the Narcotics Anonymous.
No, that's good. It's getting drugs illegally. That's your problem over and over and over again. That's your problem. Not attending help. You need to do that. You're here because you made one mistake after another. 1, 2, 3, 4, 5, 6, 7. Specific urine samples were tested and they were all positive. All right. Okay, how do we deal with it? Let's finish this.
Judge, I would like to see if we can get her in either back in the JCDI or the other program and see how she does on that. That would be the residential substance abuse program or JCDI. See how she does on that. If she does not do well, we can back address the possible safety.
Okay, what about with her pregnancy? How's that going to work?
She's eligible for those programs being pregnant.
Only eligible for residential programs, or JCDI, outpatient treatment programs, which she was currently in JCDI when she got the positives. And then she has attended a residential treatment program and was unsuccessfully discharged for fighting.
For what?
Fighting.
You weren't guilty of that either, right?
There was a verbal disagreement, sir.
You can't get along with people? Between committing crimes and so what I'm more worried about is the child. I seem to be worried about that because that's the way I am, but the well-being of the child who's not at fault here. The mother is at fault again. What are we doing? What's in the best interest of the child? Where can we put her? Because she's going to use drugs. Oh, you're not. Didn't you make a promise when you were put on probation not to?
Yes, sir, but I've been
But you violated that promise. I'm not going to trust your word.
on probation 5 years and this is my.
I'm sorry. I'm sorry. You're supposed to be on probation for 10 years. You committed, you can't say, I tripped at the finish line. I should get the participants medal. No, you didn't complete the task. The task is complete probation, which you haven't done. You've committed violations of probation. All right, what do we do?
I'm gonna suggest drug patch and residential
What
program for now, and let's see how she does till David's here.
Why not keep her in jail?
You have the ability to do that.
I know, but
think
what's
you
in the
can-
best interest of the child is what I'm worried about.
That could
I don't
protect the
trust her
child.
going out, getting access to drugs.
If you
Don't even shake your head, man.
Judge, if you want to order
read your-
upfront time, and that time can end at the time in which we can move her from there to safety, I would agree with that, because I really don't want to ask for prison time for her under these circumstances.
Now, I'm looking to what's in the interest of the child, because I don't trust them.
That is a possibility.
And they don't dispense the drugs in the jail.
No, sir. She's probably the cleanest she's been right now in quite a while.
I've been clean.
That is a possibility that you could do some upfront jail time and then safe P after that. But she's actually preferring to try to do something with a drug patch here.
I don't trust her.
One of these programs here.
I don't trust her. I'm thinking about the well-being of the child. Here's your probation order. I highlighted it in yellow. Read that out loud.
Yes.
You signed it. You promised. Read it.
I agree to follow all conditions imposed upon me, and I know that this community service can be revoked for any violation.
Okay. How many violations of that promise did you make?
3 years.
No, you didn't. You can't even tell the truth right now. No.
I thought
You provided urine samples 1, 2, 3, 4, 5, 6 times that showed positive. You were unsuccessfully discharged from residential substance abuse. That's a 7th mistake. And then failed to enter and successfully complete the JCDI. 8. But you promised. I'd agree to follow all of them. So your promises aren't resonating truth.
Serving up the child. I am.
Where are you getting your marijuana from?
I got it at the dispensary.
From whom? Who is it that's distributing it illegally?
I don't know. Like what's?
What it legally obtained at the dispensary?
Yes. They served they had items and stuff there.
Mm-hmm.
I don't
It's
know.
a legal medical dispensary. You had a prescription, they gave it to you,
I didn't have a prescription.
but they gave it to you anyway.
Yes.
All right, the police are going to talk to you about that one. I want to hear how that's happening. Because I'm sure everybody watching wants to know how to get the free drugs. What did it cost you for that? Free? They're just giving it out free? They're giving tetrahydrocannabinol, marijuana free from a dispensary. All right.
No, sir.
That's a made for TV movie. I want to see that one. We're going to hear more about that because I'm going to ask law enforcement to get to the bottom of that. That's a mess. That's ridiculous. Nonetheless, you can't use drugs. Sorry, you can't go out and buy marijuana.
No, I
Don't
didn't
even
do
talk
it for
about it.
years. I didn't know how to do it.
You have a probation officer. They were supposed to guide you, and they do. They're 93% success.
Yeah, they did great.
They did great. You failed.
Yes.
Right. So let's get to this. What do we do? I don't want to amble him about. I mean, she's buying, she's accessing drugs illegally, and she's they're giving it away for free. Well, she's not going to stop.
Yes, sir.
You keep interrupting me. You just see. You don't even follow rules of decorum, much less the rules of probation. You still are interrupting. You're going to get a chance to talk, Miss Interrupter. See, I think you kind of live in an environment where you have it on your terms only. And so you're kind of the boss of your environment, which you haven't done a good job for. And now you've got a child on the way that I'm more worried about than you are. It's apparent.
I'm going to suggest residential substance abuse treatment program backing it with a drug batch.
What's awesome.
Judge, the probation officer and I talked about it. We believe that if you order upfront time, that we can get to the point where we can put her in safety following that, but it has to be 180 days. And it's not it's the best way to get to where we know everybody's protected.
I'm going to find that there is sufficient evidence supporting this motion granted by preponderance of the evidence are greater as allegations 1, 3, and 7 are proven true. And the court can revoke your probation and sentence you up to 10 years in prison. What I'm going to do is right now continue you on probation. As a term of probation, you must serve 180 days in the county jail immediately, so that the county jail is going to be supervising you. You can't be trusted out there on your own. You've proven time and time again that you go toward the marijuana, and your child's health interest is more important to me than it seems like to you. At least in the jail, you're going to be clear of drugs through the time of giving birth for the child.
Thanks, sir.
And that's the order of the court. When after that has occurred, then we will have another hearing on where we should go. What other terms and conditions of probation need to be addressed. But the court has had enough of your illegality.
Wait, sir, may I please?
The court's rulings are what they are. And I've heard what you want, and your wishes have only caused you trouble because you have been, whatever it is about your character right now, you are unable to conform to not using drugs. And you still keep forgetting you're bearing a child which needs, whose health is of foremost importance to you. That's the order of the court. Okay, that is all. Thank you. Who's next?
Tory Morgan, something.
That sounds fun.
I shouldn't have a bigger problem with that.